Supplementary list, fresh submission item number 1.
May I please, my lord?
Yes.
Your lordship have been granting time to my learned senior for the state with regard to the allegation of the petitioner that the playground is developed at a place which has not been allocated by virtue of the order. Because I have no grievance if it is developed in the place where it has been allocated, and the record of right shows the land where it has been allocated is the school and school compound.
They are making. BDO has contacted me today itself. We will file counter tomorrow. Let it be listed on Monday. We will be filing counter tomorrow.
All right.
On Monday it can be.
Mr. Devakant Manvi informs the court that the counter affidavit will be filed within 2 days. Yes, sir. First May.
4th May.
First.
Obliged.
Item number 2.
May I please, Your Lordship? Here the petitioner appellant challenged the order of the Honorable Single Judge. The Honorable Single Judge, without interfering with the improved order, dismissed the case, madam. Your Lordship, kindly have a glance that order, madam, page 25. Since the Honorable Single Judge held that since the petitioner has not challenged the termination order, since the termination order was not communicated, and the improved order is 8/8/2008, that is page 43. They have rejected my representation, stating that the petition has already been dismissed, terminated from 1296, man. And how the order was retrospective when it was passed on 8/8/2008, and it relates to the 96. And that too, in the counter affidavit, they have stated that documents are not available. And it was only available up to 2003.
No, but did you challenge the retrenchment order? You did not.
No, that is not communicated. That is not communicated. You page 43 for a moment, kindly have a glance. This order was communicated. I have challenged this order, 8/8/2008. Page 43. That was communicated. That was challenged. For the Honorable Single Judge held that since the termination order, you have not challenged. When it was not communicated, so how can he challenge, man? And that too, the documents are not available. They have stated in the affidavit also.
You were retrenched on 1/12/96, sir.
They have stated that, but nothing has been communicated and no opportunity was given.
1 minute, sir. After 1/12/96, you attended office.
Madam, I was on leave, madam.
After 1/12/96, you have attended this office.
I was on leave, madam.
For how many years, sir?
2003, madam.
Which government gives 6 years leave?
Madam,
Which government gives leave for 7 years?
and I was on leave, medical leave, and that was with due permission, madam.
Oh, 7 years permission they gave you.
They have stated that you was retrenched, but nothing has been communicated to the
What were
petitioner.
you doing, sir?
You Lordship, for a
What were
moment,
you
please,
doing?
madam.
Suppose I stop coming to the court from tomorrow morning. I know how much leave I can possibly take, right? As an employee, I stop coming. Let us say I am working as an ASO in this High Court. All right. Tomorrow morning, I stop coming. Medical leave, casual leave, earned leave, every leave. All right. Maximum, if you total up all those leaves, how much it will come to 1 year? Outer limit. I don't keep coming for 1 year. But then I don't come for 2 years. I don't come for 3 years. Then I turn around and say, oh, I was never told of any dismissal, retrenchment.
Madam, you are merely saying that I was retrenched from service in
What
96.
were you doing? First, we'll talk about them.
Yes,
Now let us talk about you.
yes.
What were you doing? When did you go on leave?
Twenty-two to 92.
No, 1/12/91. Your facts are wrong. This is the whole problem.
That is a page 37.
Come to page 43.
Madam, they have stated that your Lordship kindly see.
Anyway, I don't see much of a difference between 1/12/91 and what 92?
22 to 92.
I don't see much of a difference. 2 months difference. Let's go by your date. So after 2nd February 1992, you never went back to work.
They are not allowed.
When did they stop allowing? When did you report and when did they stop allowing?
On 28/9/93.
So you just stayed away for how many months, sir? Just minus.
And you also kindly consider the collector has directed.
You're not willing to answer. Huh? This is a very bad trend, sir.
My lord.
Are you willing to answer the court's question or you
No.
simply argue whatever you like to? For how long did you not report for work? According to you, you gave us 2 dates now, right?
Yes, student.
Now you sit and calculate the difference. Don't give us that task.
On 28/9/93, I was intimated.
So how many days you stayed away from?
Near about 1.5 years, sir.
Near about? Please calculate correctly
Yes, yes.
and tell.
On 22/2/92, man.
Hmm.
And I reported on 28/9/93.
Hmm.
Yes.
Hmm. So which rule, which case, which judgment permits you to just
Since-
simply stay away?
Since
You
they are-
first show us the rule, sir. Show us which rule, which judgment permits you to stay away from work for over 18 months without anybody sanctioning leave, without anybody permitting you, without you offering any explanation.
since-
18 months, you simply relax. This is government service, right?
my lord.
Are you working in government, sir?
Teacher.
So you can relax, is it? For 18 months, you can stay away, then pretend, oh, I was never told that I'm retrenched.
Sir, for a moment, kindly have a glance, page 39.
You will be surprised, is it? If I was away for 18 months from working in the High Court, I should not be surprised that the High Court removed me from service. You are surprised. Your client is surprised not only now after 18 months. He's surprised when he's told in 2008 that you have been retrenched. He's pretending that he was never retrenched.
Assuming for the sake
What is his conduct? No, you come to the court. One has to test your conduct, right? What is his conduct? How do you expect any court to be sympathetic? This kind of a conduct.
page 39 for a moment, kindly have a glance.
What is there? What is there in 39?
Page 39, man.
Ah,
The DI of school intimated to the inspector, you will also kindly see, with reference to the above cited subject, I herewith enclose the original representation of Sri Shankarshan Pandya, ex-assistant teacher, primary school, Lambadanga, along with the medical certificate for favor of your kind information, necessary action, necessary direction may kindly be issued for reinstatement of the Shankarshan Pandya.
so what does the word reinstatement mean? What does the word reinstatement mean?
That
You got into more trouble now
Ma'am?
because you read this later. Now this is getting you into more trouble. What does the word reinstatement mean?
they have stated that, man.
Who's they? You are relying on this document, right? What does the word reinstatement mean? When do you use that word reinstatement?
I have repented. They have.
You don't answer questions, sir. You are in deep trouble. This is the second time you are refusing to answer a question. When the High Court asks you a question, you have to answer the question.
Ma'am.
Now, if you want to help your client, if you say, forget, I'm not bothered about my client, I'm not bothered about the court, I just have to go into the court, argue, and come away. That's fine. That's up to you.
First of all, the documents are not.
Are you going to answer this question or you're not going to answer the question? You make up your mind. You want to answer the question, don't want to answer the question.
Also, give me another opportunity.
No. First, you answer this question. What is the meaning of the word reinstatement? When do you use that word? I won't repeat this question hereafter.
Ma'am.
If you want to answer it, otherwise don't answer it. Say, sir, I refuse to answer.
Allowed to join, not reinstatement. That is the.
When is the word reinstatement used? Who uses the word reinstatement?
This one-
You're a service law lawyer.
After termination.
Your area of practice is service law.
Ma'am.
You have never heard of the word reinstatement.
Ma'am.
What does it mean? When do you use that word?
When terminated, thereafter reinstatement.
So when you use this word, you are aware that you are terminated?
Ma'am.
And you are trying to argue in 2023 that you are not aware in 29/9/93 that you were removed from service. I think we should dismiss this kind of appeals with exemplary costs. We're just going to take a sympathetic view because the man has been out of service. The whole basis, you say, the whole basis of challenging the impugned order dated 26 November 2021 of the learned single judge. No. Of the impugned order dated 2nd August 22 of the learned single judge, dismissing the appellant's writ petition civil (OAC number 1959 of 2009), was that the appellant was never aware that he had been retrenched from service with effect from December 1996. And was aware of it only when he was informed by the letter dated 8 August 2008. Stop. Accordingly, when he filed an application in the Odisha Administrative Tribunal, he did not challenge his retrenchment, but only the letter dated 8 August 2008. And prayed for its quashing. The learned single judge has, while dismissing the writ petition, observed that without challenging the retrenchment, the appellant cannot expect to get back in service by merely seeking the quashing of the letter dated 8 August 2008. Paragraph. Counsel for the appellant repeatedly urged that since the appellant was not aware of his retrenchment, he could not have challenged it prior to 8 August 2008. Paragraph. The counsel of the appellant himself drew attention of the court to a representation made by him on 28 September 1993 for single courts joining on duty, in which he admits that he was on casual leave from 21st February 1992 onwards on single court's medical ground, unquote. He also drew attention to the letter written by the District Inspector of Schools, Parlakamundi, to the Inspector of Schools, Berampur, on the said representation, seeking directions for open quotation reinstatement unquote of the petition. Paragraph. What is apparent from the above letters is that without any prior sanction at any point in time, the petitioner stayed away from duty from 21st on his own showing from 21st February 1992 onwards, and did not ask to be permitted to join duty till 2993. That is for more than 18 months. Full stop. How a government servant can presume that he could remain absent without any permission from any authority for 18 months is beyond comprehension. Stop. With this kind of a conduct, for the appellant to claim that he was not aware of the consequences of staying absent is simply unacceptable. Stop. Even when no action was taken on his representation, the appellant never thought of seeking any remedy whatsoever. For more than 7 years thereafter, more than 10 years thereafter, more than 9 years thereafter. So it appears that only sometime in February 2003, he engaged a lawyer to issue notice to the opposite party, and thereafter moved the OAT with OA number 2634/C of 2003. Stop. In that OA, an order was passed requiring the appellant's representation dated 28/1/2003 to be considered. An order was passed on 9th February 2008, requiring the appellant's representation to be considered. And this led to the impugned letter dated 8th August 2008, informing the appellant that it should be deemed to be retrenched with effect from 1st December 1996. Paragraph. The very conduct of the appellant in not reporting for duty over 18 months and then keeping quiet for over 10 years after he was not taken back in service speaks volumes, and speaks volumes as to his conduct. Full stop. It clearly disentitles him to any relief whatsoever. Full stop. Paragraph. The court is unable to find any error having been committed by the learned single judge in rejecting the petition of the appellant. Full stop. The appeal is accordingly dismissed.
Supplementary list item number 3.
My lord, in this case, the judgment of single judge has been passed. But today I have received information that some other order has been passed by the same single judge. In this case, he had said that the revision order passed under section 15B of Odisha Survey and Settlement Act is not maintainable in jurisdiction and go for civil mechanism. But otherwise order has been passed. I have to verify just 2-3 days time, my lord.
But you have to go to the civil courts. There are rival claims as to title to the property, right?
When there is a rival claim, the honorable court said that. Otherwise,
the
when
civil
there is a
court.
claim against the government,
Correct.
that your lordship is.
Yeah.
But matter is the order passed by the commission under section 15B that should not influence the civil court.
That is up to, you see, the impugned order relegates the appellants to the remedy of a civil suit to settle the rival claims between the appellant and the contesting respondents regarding title to the property in question. And accordingly, the learned single judge has declined to interfere with the order dated 22nd September 2021 passed by the Additional Commissioner of Settlement and Consolidation, Cuttack, in RP case number 446 of 2014. Paragraph. Since these are rival claims between private parties, the private parties, over the question of title, no fault can be found with the impugned order, relegating the appellants to the remedy of a civil suit. Full stop. It is nevertheless clarified that the civil suit will be decided on merits on the basis of the evidence led by the parties, uninfluenced by the order passed by the Additional Commissioner under the Orissa Survey and Settlement Act. All right. With the above observations, the court declines to interfere with the impugned order. The appeal is disposed of.
Item number 4.
My lord, yesterday, out of same judgment, 3 appeals. Yesterday, one was there. My lord have directed these 2 cases to be listed. 22-6. It has
All right.
been
List on 22-6
along with WA number 137 of 23.
All right.
In
Yes,
these
sir.
2 cases, I'll file my power within a week.
All
I
right.
pray, my lord, I may be
Yes,
solved
sir.
with
Yeah,
Same
copy of the present appeal be served on Mr. Samir Mishra,
I'm obliged.
advocate for the respondent, contesting respondent.
Item 4 and 5. Item number 6.
May kindly adjourn.
Why, sir?
Mr. Ponda is absent.
Pandaj?
Absent.
That's not the ground, sir. Tell us what the matter is about. Because last time also it was adjourned at his request. Insurance claim. The present petition, projected as a public interest litigation, seeks to question the order passed by the Collector and District Magistrate Sambalpur on 20th December 2021, rejecting the representations of the petitioners. Earlier, the writ petitioners had filed WP Civil 16737 of 2021, which was disposed of with this court on 17 September 2021, requiring permitting the appellants to make a representation to the collector, who would pass an appropriate order after giving them a hearing. Full stop. Paragraph. The appellants have been heard by the collector and the impugned order has been passed.
And
The submissions of the insurance company was also taken into account. So it has been noted that all eligible farmers have in fact been settled. The insurance claims of all eligible farmers have actually been settled on the basis of the list of beneficiaries. Paragraph. Since obviously the claims would involve disputed questions of fact, it is not possible for the court in this writ petition to adjudicate such claims. Full stop. It is clarified that if any individual farmer is aggrieved by the rejection of his claim, it will be open to such individual farmer to seek other appropriate remedies as may be available in accordance with law. The court, with the above observations, declines to interfere, and the writ petition is dismissed in the above terms.
Item number 7.
7 is case regarding PIL, my lord.
Seven is a PI.
Evolution of
Union.
Item 7.
my lord, in this case is regarding PIL, my lord. Abolition of level crossing. After abolition of level crossing, more than 5,000 people are affected, my lord. Thereafter, this case is initially filed before the Honorable Court. Honorable Court direct the General Manager on 4/5/22 to verify and pass appropriate order. But without verifying, my lord, on 17/8/2022 is pass order, which is challenged in this case, my lord. My lord, on 6/1/2021, for the effect of the 5,000 people, MLA also sent a letter to the railway authority not to abolish the railway level crossing, as people are, after abolition of the level crossing, people are very much affected, my lord. Thereafter, inquiry is also conducted by the after examination of the representation by the collector. Collector directed the Tahsildar to examine the matter on 2/7/22. Inquiry report annexure 5, my lord. Inquiry report was sent to the railway authority that after abolition of the level crossing, more than 5,000 people are very much affected, as both side agricultural and medical, 2 ponds, cremated, everything is here. That's why, my lord, there is a annexure 7, my lord. Can you see annexure 7?
So you can pray for some overbridge. You need to-
Yes.
I may be pardoned, my lord. I am appearing on behalf of OP number 1 and 2. My lord, annexure 7 is clear. My lord, the policy guideline, as per policy guideline, there was they have taken a decision to eliminate the manned level crossings, which are a safety hazard. And by annexure 6, page 37, my lord, kindly come to point number 2. What alternative road arrangement has been made by East Coast Railway for thousands of villages using this road? My lord, the compliance is connecting road made for villages and connects LC number 210 to LC number 209. Already there is a road.
In annexure 7,
LC is level crossing.
yes,
Level crossing, my lord. Level crossing number 210, that they are insisting not to eliminate that level crossing. Number 210.
No, so how is this an answer? The connecting road means what?
No, this they have provided the information that there is a connecting road that has been
So all the people who are using 210 will go to 209 now.
my lord,
Is that what it means?
what alternative road arrangement has been made by the what alternative road arrangement has been made by the East Coast Railway for thousands of villages using this road? That answer is, they have given that there is a road connecting this level crossing to the other level crossing.
No. Does that mean, suppose I go in a scooter, earlier there was level crossing 210.
yes.
Now I will go to 209. Is that what you mean?
No. But my lord, this letter has been given by the senior divisional engineer.
No, I didn't ask who gave the letter. My question to you is, imagine yourself on a scooter, all right?
My lord.
Earlier you would use 210.
My lord.
Now you find it closed. Correct?
My lord. Yes, my lord.
What will you do? As per this answer, what will you do?
Provide alternative road.
No. So you will go to 209, is it? Is that what you're trying to tell me? Because there is a connecting road people who were using 210 earlier will now use 209. Is that what it means?
I will take instruction whether they have this road is an alternative to the closure of LC gate number 10, 210 or not. I'll take instruction. My lord, may kindly
Well,
post it.
my lord, Annexure 7 is very clear, my lord. My lord, there is, if there is no ROB, then RUB also constructed by the railway. Railway under overbridge, my lord. If evaluation ROB overbridge, then railway also constructed RUB, railway underbridge, my lord. Then people can not to hazards anything, my lord.
Yes, Mr.
My lord, the first time it was listed, we'll take instruction. It is better to appraise the proof.
Mr. PK Party learned DGI states that he will take instructions on the alternatives to the closure of level crossing 210 and whether there's any proposal to construct either a railway overbridge or a railway underbridge. At the relevant place. Question mark. And his request list on 27 June.
My lord, let me reflect Josna sir along with me.
All right.
Item number 8.
The defect, my lord, I will remove it by next week, my lord. There's a defect and discrepancy in the Bhakavatnama, my lord. I execute it by next week, my lord. Other defects I have cured.
1 minute. Let's see what this matter is about.
It's a PIL matter, my lord.
Once your lordship has directed the collector to consider their grievance and collector
Collector has rejected our grievance.
At page 20, the order is there. This is
Let's see what that order says.
all the points the collector has taken into consideration and a speaking order has been passed.
How can, when you change a plot plan, how can you say it doesn't involve public interest?
Yes.
See, you're converting 600 square feet plots into 1500 square feet.
Those were left for park
So
and
what is meant for EWS
yes, ma'am.
is now not available for EWS, only for MIG. And that you say is, that does not affect individuals. It's not, doesn't involve public interest. How can you say that? It's a major change, sir.
Other contingency are due to situations beyond.
There's no need. 1 minute, sir. I'm putting
sorry.
something.
I'm sorry, ma'am. I'm sorry.
Don't button. It's bad advocacy.
I'm sorry.
When you should know when the court is in your favor and when it is
I'm
against
sorry,
you.
madam. I'm sorry.
A major change in the that is
And how can you say it doesn't involve public interest? You say the court has produced the order, impugned order dated 13/10/2022 of the collector, which appears to proceed on the basis that conversion of 600 square feet plots into 1500 square feet plots, and thereby keeping out an entire EWS category from allotment is not a major change and does not affect open quotation individual interest or public interest. Stop. Prima facie, this appears to be erroneous. You say notice. Mr. Mahanti accepts notice on behalf of opposite parties 1 and 2. Notice to opposite parties 3, 4, and 5 returnable on the next date. The tracking report be placed in record. Counter affidavits giving parawise reply be filed within 4 weeks of service of notice. Rejoinder thereto if any be filed for the next date. List on 17 July.
Oh, bless, ma'am.
All right.
Item number 9.
Meanwhile, defects we cure.
Please, Your Lordship. The petitioners challenging the action of the OP 5 and 6 in constructing the work over the Gochor land submitted reportation on annexure 2 to the collector OP2, stating therein that the available Unnata Yojana Yogya land is available in that village in the same Khata 392. Instead of utilizing that Unnati Yojana land, constructing up over Gochar land without resorting Gojilis.
They've just got this on 3rd April.
Yes,
Today is what date?
19th.
You want miracles to happen.
Why? Because once there is a utilization of public fund, it will create problem. That's considered by the collector. Once there is a utilization of public fund by huge more public money out of the public.
Sir, April, who's utilizing public money in April? The budget is over.
Nowadays, the developmental work is highly progressive in the state. That's why our OP2 may be considered.
After giving 3rd April, you're coming to the court. When did you file this petition?
OP2 may consider annexure 2 only.
12th April.
12th
And
April.
there is
11th April, you filed it.
There is no
3rd April, representation is reached. 11th April.
Only happens on once there is a
Which
utilization.
government treats representations and gives an answer within 1 week?
and proof of delivery also.
It's a miracle. You're expecting miracles.
Emails, that email that
You're expecting miracles. 3rd April, they received your representation. 11th April, you've come to the court.
Only prayer OP2 may consider annexure 2.
I like your
that annexure 2
pretension that what I'm saying doesn't matter at all. This is remarkable.
That is the grievance.
You just have to keep saying what you have to say. You say, after receiving an acknowledgement from the government on 3rd April 2023 of the representation made by the petitioners, they waited just for 8 days to file the present petition. Full stop, it is obviously premature. Once the court expects the respondents to consider the said representation in accordance with law, and after hearing the petitioners to communicate the decision.
My lord, provided it is delivered, because there is no proof of delivery.
No, there is.
There is Jana.
That is in May.
Jana Sunani.
No, 3rd April.
E-portal.
Page 18.
18, 19 and 20. E-portal, that government has introduced the e-portal job.
Correct. Not later than 1st July 2023. How do you say not 1st July? Say 10th July 2023. If agreed by the decision, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of.
Item number 10.
Obliged.
Please on VC, my lord. My lord, I pray.
What has happened?
Well, I pray, my lord, 7 days may be given to remove the defect, my lord.
No,
But
but no, it's all right. There's no right to adjournment like this.
No, my lord,
First adjournment means can't argue because it's first hearing. We can't argue. We have a right to an adjournment.
I'm sorry, my lord.
No. Just tell us this impugned order is 6th July 2018.
My lord.
And you filed this in 2021.
My lord.
Tell us why did you wait for 3 years?
My lord, because some ambiguity was there, my lord, and there was a conversation was going between both the parties, my lord. Because this plot was after sold out, my lord, the relatives of that proprietor, they have claimed that the land was sold out without their consent, my lord.
This is not sufficient ground, sir. Not sufficient.
My lord, in between I have to remove the defect and I can appraise, my lord.
First of all, you can't tell us in the writ appeal where is the explanation for the delay. First of all, is there a delay application? No application itself for delay, sir. How many days delay? 911 days. Oh, I see. For 911 days, no need for application.
My lord, I have to file a limitation petitions, my lord.
Only now. See, this itself was bad enough, sir, that you waited for 3 years to file writ appeal. Then you're still waiting for 2 years to file application for delay.
I'm sorry, my lord.
No, you don't have to be sorry. We have to be sorry for your clients. It's a hopeless case, sir. Can't improve it. There's a delay of 911 days in filing the writ appeal against the full stop. The writ appeal was filed on 2nd February 2021 to question an order dated 6 July 2018 of the learned single judge. Full stop. Not only is there no explanation, there's no application for condonation of delay filed in the last 2 years, but worse still, even the memorandum of appeal contains no argument explaining the delay. Consequently, the court is not inclined to entertain the present writ appeal.
I pray another date may be given. I have to apprise Malad.
No.
I have to apprise Malad.
It's all right. And the writ appeal is dismissed on the ground of delay.
Item number 11.
Extraordinary unexplained delay. Right.
Item 11.
Item 11, I may permitted to withdraw with liberty to file a review.
I'm giving that order.
Same order.
Item number 12.
Review the file.
Again.
File review, my lord.
Item 12.
Item old pension 25th April.
I'm sorry, Your Lordship, I have given the wrong order.
Yeah,
I beg.
Last will not be there. No, you were saying withdraw to file a review.
Yes, see, I have given the wrong order, Your Lordship.
That's
I'm sorry. I beg apology.
All right, same one.
Item number 12.
Old pension 25th April.
25th.
Item number 13.
13, my lord, I am permitted to withdraw.
Dismissed.
I am appearing for the opposed parties. My JK Pana name be reflected.
All right.
My lord, withdraw.
No, 30. Council.
Item number 14.
Item 13, petitioner is died. And here a claim is for family pension. So I want to file a petition for substitution of this daughter. The claim is for family pension. At paragraph 5, will indicated that she has been blessed with a daughter.
Let's see the impugned order.
The petitioner died.
There's a rival claim, sir, for pension.
Since petitioner died, I want to.
No.
She should be substituted.
Just read the impugned order. You have read the impugned order?
Miller? Yes, impugned order. Miller, there is a finding of the civil court that the petitioner is entitled to family pension. In spite of that, the state government pension against the OP number 5. And I have also filed a miscase in first appeal pending. There the court said that only because of the findings, this is not possible. And again, he said that so alternative, there is no alternative than to approach this honorable court.
I'm not able to understand, sir. Just read the impugned order.
This serious dispute regarding entitlement petitioner or private opposite party herein. It is alleged that the private opposite party herein is being granted family pension wrongly. For the nature of controversy involved herein, writ petition not meant.
So you are the first wife. First of all, you have to tell the facts correctly.
Miller,
the appellant was the first wife.
Yes, Miller.
The rival is respondent number 5, who is the second wife.
Yes, yes. She is the respondent number 5.
So who went to the civil court?
Yes. The appellant went to civil court. And kindly come to Miller, page 36. The findings of the London Civil Court. I have filed. The judgment I have filed. Page 36, I am reading. It has been held by our Honorable High Court that marriage solemnized between two Hindus, when any party to the marriage has a spouse living, at the time of marriage is null and void.
No. This appellant is the first wife,
Milord,
and she has died.
she died.
Then family pension will be payable to whom?
To the widow.
She's died, no, sir?
She died, but this daughter is also entitled to the arrears.
Is she? I don't know. What is the scheme here?
Scheme here, if she died and entitled to pension, the daughter is entitled to the area pension.
Is that the scheme? I don't know.
Yes, yes.
How is that? What?
You see the married lady,
Then how will she be entitled, sir? Then she will not be entitled.
The pension is the right of the wife.
Correct.
So also the daughter.
How? Not so also the daughter. What is the scheme? I think it's not for married daughters.
No, married daughter will not take the pension, but she will be entitled to the areas. This is my argument. So let me to first add her as a party. Then I'll be arguing. Since
No. First you find out the law, sir. Unnecessarily adding parties. What is the law?
Lord, that she is not entitled to family pension, but she is entitled to the dues of the deceased mother who died. Till death of the mother, she is entitled to the arrear pension because that is the right of the mother.
Where? Which is that law which says that married daughters are entitled to family pension? I'm not sure.
Here is the arrear pension, not the family pension.
The estate of that woman.
The arrear family pension of the mother. She is entitled to the arrear family pension of the deceased mother.
What does it all work out to? What does she do?
Millard?
How many legal representatives are there?
Millard?
How many legal representatives are?
Only one.
How is that possible? There's only one child, is it?
Yes, Millard.
What about the
I have indicated that in my paragraph 5 of the OA. That out of their overlook, they have blessed with only daughter, namely Tusharakanti Nath, who has already been married. And
what about the second wife?
Millard?
What about the second wife?
She is alive.
No.
Whether the second wife has any children?
Yes.
Then they are also entitled.
She has 3 to 4 children.
Then they are also entitled, sir.
The children of the second wife are also entitled.
You are talking of estate, right?
They are not, but they have not come. They are also major and married. So my humble submission is
all this is in speculation.
The married daughter may not be entitled to family pension, but she is entitled to arrear pension of her mother.
No. So what happened when this was a partition suit which was decided?
Partition, there is a findings of the Honorable Court.
No. The Annexure 4 is a decree in a partition suit.
Yes, similar. Kindly comes middle at page 36. There the observation of the civil court is there. Accordingly, second marriage between Govindanath with defendant note 4 is null and void. She is not entitled to a share on Exhibit 8, will not help the defendant, and she is not entitled to receive family pension. As she has managed to maintain her name in the family pension in the pension book, influencing late Govindanath, as appears from the evidence. Accordingly, this issue answered in favor of the plaintiff.
Against this, appeal is filed.
Yes, the defendant number 5 has filed first appeal that is pending here.
So which is why the court is saying, depending on the outcome of that first appeal, this whole issue can be decided. If that first appeal is allowed, then you will not, your claim will go. If that first appeal is allowed, your claim will go, sir.
With that observation,
that's it. That's what the single judge has observed. You see, the dispute between two wives of late Sri Govindanath for receiving family pension forms the subject matter of the present appeal. At the outset, counsel for the appellant informs the court that the appellant expired on
date is not noted.
You don't know the date.
Simply information is died.
He is informed that he states that as per his information, the appellant has died during the pendency of the present writ appeal, which was filed on 26th March 2021 against the impugned judgment dated 28/1/20, order dated 28/1/2021, passed by the learned single judge, dismissing writ petition civil 38798 of 2020. Full stop. Paragraph. The prayer in the he accordingly prays that the appellant should be substituted by her sole legal representative, that is her daughter,
Tushar Kanti Nath.
Tushar Kanti Nath,
Paragraph 5.
who is a major and is married. Full stop. Paragraph. The prayer in the writ petition was for a direction to opposite party state to, open quotation, stop payment of family pension to opposite party number 5 and to grant family pension in favor of the petitioner and release the arrears as well as current pension to her, unquote. Full stop. The basis of the above claim was a judgment and decree dated 3rd April 2004, purportedly, passed by the
Yes, number 76 of
additional
2000.
ad hoc additional district judge, Jajpur, in title suit number 76 of 2002, where inter alia it was held that respondent number 5 was not entitled to the family pension payable on account of the death of Sri Govindanath. Paragraph. Admittedly, respondent number 5 has filed an appeal.
RFA number 98 of 2004, paragraph 13.
Being FAO, is it?
RFA number
RFA
98 of 2004.
98 of 2004 against the said judgment of the civil court, which is stated to be pending in this court. Stop. Paragraph. In the above background, the learned single judge has, in the impugned order, observed that the question as to entitlement to family pension would depend on the outcome of the above appeal. And further, that if the said appeal is decided against the present appellant, she can seek other appropriate remedies available to her in accordance with law. Paragraph. Given the background, given the above facts, the court is unable to find any ground to interfere with the impugned order of the learned single judge. So clearly, the entitlement to family pension will depend on the outcome of the above appeal pending in this court. Consequently, there is no merit in the present appeal. It is dismissed as such.
Item 15.
The appeal may be disposed of.
All right. All the
Instead of dismissed, they may be disposed of.
Yes.
Item number 15.
Against the impugned order passed by the Honorable Single Judge, a batch of writ appeals were preferred, Your Lordship, and in the meantime, they have been dismissed. I'm forwarding the copy of the order, Your Lordship.
Yeah. Against the same impugned order, it is common to a batch of petitions. This court has already dismissed WA number 246 of 2021 by orders dated 23rd April / 11 June 2021. Couldn't have been 2 dates like this.
The first, which was dismissed, the writ appeal number 247/21.
Oh, I see. By order dated 23rd April 2021 in writ appeal number 247 of 2021. Accordingly, the present writ appeal is also dismissed.
Item 16.
Item 16 was DLR 25th April.
All right.
Item 17.
17, I prefer a passover, my lord. Not just.
Item number 18.
18, 19, 20, 21, 22, 23, 24, 25th April.
All right.
Item 24.
Up to 24, 25th April.
Item 25 now.
25, 30th August rehabilitation.
Item 26.
8th of May.
Yes.
Item 27. Item number 27.
Appearing on VC, Your Lordship. Your Lordship, due to personal difficulties of Mr. on behalf of Dr. Lenka, Your Lordship. Due to personal difficulties of Mr. Lenka.
Yeah. The counsel for the appellant stated in some personal difficulty. July.
Oblige, Your Lordship.
Item 28.
None appears dismissed.
Item number 29.
29 में 8th में शर्त पड़ा.
Item number 30.
None appears dismissed.
Item number 31.
Rehabilitation 30th August.
Item 32.
32 मतलब the Lordship has already decided the similar issue. Page 63, the impugned order. That first, the Lordship may see that order. Kamalakanta Das, the Lordship has already decided the issue.
All right. In view of the order dated 28 September 2022, in writ appeal 1020 of 2022, bracket, State of Odisha versus Kamalakanta Das, the present writ appeal is disposed of in the same terms.
Item number 33.
33 vigilance is promotion during pendency of vigilance 11th May.
Item 34.
In this case, I am appealing for the appellant, my lord. Play some time because IA has been filed. In the meantime, management of the company has been changed due to amalgamation. So as the IA is ready with me, my lord, I'll be filing it today. Let it come with the IA next week, my lord.
Counsel for the appellant points out that the management of the appellant has changed.
Yes, ma'am.
And he would like to file an IA today, is it?
Yes, today, in the course of
to bring the above development on record at his request list of. July.
May I pray any day before vacation?
Come. IA will come up earlier. Yes.
Item number 35.
And appears dismissed now.
Item number 36.
Ma'am, I am from the appellant, my lord. Here in the case, my lord, the appellant was promoted to the rank of inspector of police, my lord. On my lord,
6/10/2094. And he was allowed to officiate as Inspector of Police. During that period, he was suspended and a departmental proceeding was initiated, my lord. Thereafter, that department, he challenged the proceeding before the tribunal, my lord. On the order of the tribunal, by virtue of the order of the learned tribunal, his proceeding was dropped, my lord. Thereafter, he was superannuated from service, my lord. My claim is that since the proceeding has been dropped, the promotional benefit and promotion may be accrued in favor of the petitioner, appellant, my lord. But the Honorable Single Judge, my lord, kindly see page 47, my lord, the impugned order, my lord. Honorable Single Judge stated that the proceeding has dropped, my lord, but he has not allowed the petitioner for promotion. My grievance is that since my proceeding was dropped as per J Department circular.
So that promotion prayer is not even dealt with.
My lord.
No, has the promotion prayer been dealt with?
I have made that prayer in my kindly see the prayer portion.
The single judge has not dealt with that.
Not dealt with.
We are saying something in your favor, sir.
Yes, madam. He has granted in favor, but
he has granted you favor. I think he's not understood. 1 minute.
Sorry.
My English has become very poor, sir. Just
The learned second judge has not dealt with your prayer for promotion.
Promotion, man. That is my grievance, man.
Should we say that you will deal with the promotion aspect also?
Yes.
All right. The only grievance made in the present appeal against the impugned order dated 20th September 2022, passed by the single judge, disposing of WPC bracket OAC number 2367 of 2018, is that it does not deal with the prayer made by the appellant that he should be promoted from the same date. With that, with the disciplinary proceedings against him being dropped, he should have been promoted, granted promotion, on notional basis, bracket post his superannuation, bracket, from the same date when his juniors were promoted. Paragraph. Indeed, a perusal of the impugned order does reveal that the above prayer of the appellant, clearly made in the application before the Orissa Administrative Tribunal, which got later transferred to this court and was registered as a writ petition, contained such a prayer. Paragraph. In that view of the matter, the impugned order of the learned single judge is modified by directing that the respondent number 2 would take a fresh decision on the question of treating the period of suspension as being on duty, and also the question of granting promotion to the appellant on notional basis, but with consequential benefits in the above terms. We'll stop. The opposite party will now communicate its fresh decision on both aspects to the appellant within a period of 12 weeks from today. The writ appeal is disposed of in the above terms.
Item number 37.
May I please your lordship? This is a case of electrocution, but the honorable single judge held that it is not a electrocution case. Your lordship clearly that is indicated in the post-mortem report, which has not been perused properly by the honorable single judge. Your lordship said 47th page of the post-mortem report of the medical. It is, may I be permitted to last cause of death? What is the cause of death? There is in the.
And to go to the civil court for this, sir.
My lord.
Please go to the civil court. All these are disputed questions of fact.
So case, my lord.
You're found, the body is found at a great distance, 40 feet distance. So whether that the electric current caused it or not, it's a question for evidence.
Evidence
It's not obvious.
And permitted to, that is the limitation part maybe.
How can we say? There's no question of that.
Because
that's for you to decide. You say the impugned order, by the impugned order dated 30th August 2022, the learned single judge has declined to interfere in WP Civil number 22306 of 2016, filed by the present appellant, for a direction to the opposite party, or respondent, sorry, direction to the respondent electric company. A respondent was 1 and 2 electric company, that is TPCODL, to pay compensation to the appellant at the sum of rupees 5 lakhs for the death of a father as a result of allegedly coming to contact with an electric pole in the morning hours of 19th October 2016. Paragraph. In the impugned order, a perusal of the impugned order reveals that the above claim was heavily contested by TPCODL, which contended that at the highest, TPCODL will consider applying the policy of state regarding ex gratia compensation. No, that the collector would consider, not TPC. In other words, it was not obvious that there was a negligence on the part of TPCODL, which resulted in the death of the deceased. Paragraph. As regards the above aspect of the liability, if any, of TPCODL, it is apparent that in view of the disputed questions of fact involved, the better course would be for the appellant to seek other appropriate remedies as may be available to the appellant in accordance with law. With the above observation, the court declines to interfere and the writ appeal is disposed of.
Item number 38.
So far the 38 is concerned, my lord, I am at VC at here Puri, my lord. My response submission, my lord, so far the annexure 1 is concerned, that is being impugned, hereby challenging writ appeal. Specifically, the Lord and the single judge also dismissed the writ application on 2nd December 2022 on the ground of the limitation. Sole ground is a delay, that is 7 years. On the ground of the limitation, the Lord and single judge was pleased to dismiss my case. But my submission before your lordships, my lord, so far a delay is concerned, in pursuance to reported decision, my lord, 987, Supreme Court page 1353. Where there is in pursuance that landmark decision, in case of the collector land acquisition Anantnag versus MS Khatiji, the Honorable Supreme Court intervened and held that where there is a delay, liberal approach should be done, my lord. And Honorable Supreme Court also inter alia framed 6 points in which Honorable Supreme Court was pleased to contended that in case of the delay, the liberal approach should be done, as well as in case of the delay, the lenient view should be taken. So my respectful submission in this regard, I humbly submit, for sake of the interest of justice, my lord, matter may be remitted back to the Lord and single judge to take up the limitation afresh by filing a fresh application.
No. What was the explanation offered? The delay is 7 years, so you have to offer a reasonable explanation for the delay. Even if you want the court to take a liberal approach, the explanation must be at least reasonable, sir. What was the explanation offered for the 7 years delay?
My lord, my respectful submission, my lord. So far, the condonation delay is concerned. The specific SOCAT or specific as the sign point on. In that case, the humble petitioner.
No, the application had just 2 paragraphs, sir.
My lord.
Just read that first paragraph of that application.
My lord.
16385 of 2022.
My lord. So far, my petition before the Lord and the single judge is concerned. Hearing number 16319 of 2022. In that interim application, I raised 2 points. Firstly, the humble petitioner is a poor scheduled caste person. He has no knowledge about the code of procedure, and being a poor person as well as scheduled caste person, he also approved the honorable single bench in delay being aggrieved, impugned or passed by the Lord and Commissioner Constitutional.
No, there has to be an explanation, sir. So normally there's an explanation saying I was not aware of the order. I became aware of the order only on a certain day. There's no such averment here. Please read your averments in para 1.
The petitioner could not ventilate his grievance. That point I have also raised. In that point, my lord, I may point that the order of the commission was passed on 17 April 2015 and certified copy was received on 4th July 2015. Although application was moved on 11th July 2015, and petitioner being a illiterate poor SC person could not file a petition within time limit. Meanwhile, pandemic corona attracted on 23 March 2022.
Corona was there only, corona started almost 5 years after the impugned order, sir. You still have to explain 5 years delay.
Liberty, my lord. Liberty, I pray, my lord. I will file a fresh application before the launch.
No, sir.
And my response submission, the case is based on merit, my lord. So far the commission order is concerned, that is perverse in nature, my lord.
Whatever. You have to come in reasonable time. All remedies have to be sorted in reasonable time, sir. Or the explanation for the delay has to be convincing.
My response submission, the due diligence, so far the case is concerned, that is based on merit, my lord.
No, maybe.
I should be given opportunity. I should have given opportunity.
I know. We have to only consider the single judge was right or wrong, nothing more. You say this writ appeal is directed against an order dated 2nd December 2022 passed by the single judge dismissing the writ petition civil 32336 of 2022 filed by the present appellate on the ground of extraordinary delay and laches of 7 years in filing the writ petition. Paragraph. The order challenged in the writ petition was passed on 17th April 2015 by the Commissioner Consultation Odisha in revision petition number 318 of 2012. Full stop. The writ petition was filed on 28th November 2022, accompanied by an application for condonation of delay. Full stop. The application itself is only of 2 paragraphs. And para 1, which offers the explanation for the delay of 7 years, reads as under. The reproduced para 1 of the IA in the writ petition. So IA is 16385 2022. Paragraph. Counsel for the appellate relied on the judgment of the Supreme Court of India in Land Acquisition Collector Anantnag versus MST Katishi, AIR 1987 SC 1353 to urge that in land acquisition in cases concerning land disputes, a liberal approach has to be adopted by the court on the question of delay. Stop. Paragraph, the court finds that the only explanation offered is that the appellant belonged to the scheduled caste, was poor and illiterate, and therefore could not file the writ petition single quotes within time, unquote. Full stop. The explanation offered in para 1 of the application, as extracted here and before, is neither convincing nor reasonable. Full stop. The Corona period started nearly 5 years after the impugn order was passed by the Commissioner Consolidation. And therefore, there had to be some convincing explanation for the delay of 5 years at least in filing the petition. Full stop. Merely stating that the appellant was poor and therefore could not file it within time is indeed not a convincing explanation by any standard. Clearly, on the appellant's own showing, he had a certified copy of the impugn order on 4th July 2015 itself. Full stop. Some attempt had to be made to explain, if not every day's delay, then at least every month's or year's delay in filing the writ petition. Full stop. No such explanation is forthcoming. Paragraph. Consequently, the court is unable to find any error in the learned single judge rejecting the appellant's writ petition on the ground of delay. The writ appeal is accordingly dismissed.
Item 39.
My Lord, the writ appeal is challenged against the order passed by the Honorable Single Judge. There is a delay, my Lord. The defect is there is a delay. I filed an application for condonation of delay.
That's all right.
While I was going through that,
at least during the Corona period, so that's all.
No Corona, sir. Here I suffer. But my Lord, there is I found from the, I was going
so we are saying
today,
something in your favor.
My Lord?
We are saying something in your favor in case you've missed it. We are saying something in your favor, sir.
Sir,
we are inclined to condone the delay.
Yes, madam.
Now will you go on to the merits?
Yes, my Lord. Yes. My Lord, your Lordship can have a look to at page 97, my Lord. Earlier, the petitioner approached this honorable court, and the honorable single judge in WPC number 1965569 2015, taking into consideration of the services rendered by the petitioner in different law colleges and taking into the consideration of the law established by the Honorable Appeals Court. In the case of N.N. Swami versus State of Orissa versus N.N. Swami, observe, your Lordship can have a look to the last page, that is 106. For the above disclosures, it appears that the aspect of the petitioner's continuance in 2 spells in constituent colleges of Utkal University in a solitary matter of fact of the consideration of the case of the petitioner for his entitlement pension, be that as it may, for the disclosure of the above period of working in India University and the provisions of Statute 1990, clearly converting such cases of pension. Further, if the period is kept into account along with the period of service of the petitioner in Sambalpur University for about 8 years, it appears petitioner has qualified service of more than 10 years, thereby becomes entitled to pension. For the production of the material satisfactory above aspect at this stage, the court observes such aspects of the matter cannot be ignored while considering the case of the petitioner in the matter of the pension. The court here observes in the event such material was available with the competent authority, then the impugned order must go and petitioner to be paid pension, taking into account he is working in the constituent law colleges of Utkal University and the period spent in Sambalpur University. But, however, in the event of the information of petitioners working for more than 6 years in Constituent College of Utkal University was not available for consideration, this court finds there is requirement of reconsideration of the case of the petitioner for pension by competent authority. By that, my lord's direction is given, I gave a representation, and ultimately the university held that I was not having 10 years of continuous service for which the pension was not granted. I approached this honorable court. This honorable court, without taking consideration of the service rendered by the petitioner in the constituent colleges of different universities, for which, my lord, the pension rules are also made applicable, counted that the service of the petitioner is 8 years or more, therefore the petitioner is not entitled to pension. Though in fact the petitioner has worked more than 32 years of service in different constituent colleges.
No. The court did not straightaway accept your explanation, sir. They said you can make a representation giving the details and they will examine it and find out whether you are entitled for pension or not.
Yes, my lord. The university took a different view. I challenged that before the honorable court in the WBC number 6122 of 2020-21. And this honorable court, my lord, while deciding the matter, the judgment by annexure 1 at page 22 decided that since I did not have 10 years of qualifying service to my credit, I am not entitled to the pension. Though, my lords, I have completed 32 years of service.
No, but you have not got qualifying service.
I was having the qualifying service at Sambalpur University. I was having the qualifying service in the Utkal University.
No, not in Utkal University.
Yes, my lords.
There you were in an unaided college.
My lords, for unaided college also pension rule is made applicable. My lord, that has not been taken care of by honorable single judge. Under the aided institutions rule, my lord,
unaided, I think this is unaided.
No, my lords, the rule is the period covered before 82, after 82, if somebody gets retired, the services rendered under the, my lords have decided recently, the period covered under the...
Sir, I'm not, my memory is very poor, sir. I'm not able to verbatim reproduce the rule. Maybe you can. For me, I have to read the rule, sir.
Yes, my lord.
That's one weakness I have. Unless I read the rule, I cannot understand.
I'll place it some of the day, my lord.
You don't have the rule also. The whole case is based on the rule.
I have not brought the rule, my lord.
The case is based only on the rule.
Yes, ma'am.
And you have not brought it.
I thought that recently
all pension rules we remember verbatim.
My lord, I know that.
That's difficult, no, sir? How is it rule is not quoted in your writ petition, in your writ appeal?
My lord,
nowhere.
I'll just place the rule.
No, but must be there somewhere.
I understand my difficulty, man.
No. Has the single judge not dealt with the rule?
Because they have, my lord is even if in aided institutions, if anybody has worked.
So let's come to, I think they have. Just come to page 36. Just read it now. The single judge has cited the rules, quoted the rules.
36, my lord.
Para 9, sir. Para 9 of the impugned order.
Yes, my lord.
Kindly read it,
sir. Before delivering the issues of concerned legislature, etc., it is worthwhile to refer clause 260 of the Orissa University First Statute, 1990. Clause 260 of the Orissa University First Statute, counting past services. The period of qualifying service rendered by an employee under any of the following institutions shall count for the purpose of gratuity and pension. State government, any Indian university, any college affiliated to a university or state and aided by the...
Correct.
Yes, and aided by the state government. My lords, even if a college is affiliated to the university, without getting aid, would also cover.
How?
But because that is what any college affiliated to any university of the state and the aided by the state government.
No, this is one class, sir. This college which is affiliated has to be aided. That's what it means. Otherwise, that would have become D.
The Board of Secondary Education.
C is one category. C is a single category, sir. You cannot split up C into two categories. You have one category A, another category B, a third category C, a fourth category D, so on.
Yes, my lord.
So C is one category. That one category talks of any college affiliated to any university of the state and aided by the state government.
Yes, my lord.
That college which is affiliated has to be aided.
My lord, this has taken note of my NN Swami's case, my lord. Your lordship can have a look to that. That has been quoted.
Where is it quoted, sir?
My lord, that has been quoted at page. Page 7, my lord, of the writ appeal. 8 lines from the top. Honorable Apex Court in the case of State of Orissa and another versus NN Swami and others reported in etc. as follows. For the above disclosures, it appears that the aspect of petitioner's continuance in 2 spells in the constituent college of Utkal University is a solitary material for the consideration of the case of the petitioner for his entitlement of pension. Be that as it may, for the disclosure of the above period of working in Indian University and for the provisions of the Statute 1990, clearly covering such cases for pension. Further, if this period is taken into account, along with the period of service of the petitioner in Sambalpur University for over 8 years, it appears petitioner has qualified services of more than 10 years. This is what might not be. This is the first quotation.
No, sir, this does not talk of aided and unaided colleges.
My lords, as your lordship has posed me a question, if unless it is an aided one, the pension rule will not have an application. That, my lords, that rule I will quote.
That's the rule we read now. We just now read that rule, sir. 260 of the statutes. If you come to the single judge's order, that's precisely what the single judge is discussing.
My lord, the provisions of the rule which stipulates that even the periods of service rendered by an employee, when the institution is not unaided also, will be taken as per the granting aid, as per the pension rule 1981, my lord.
Not, sir.
That is prestige. My lord, to be more perfect.
Just come to top of page 37, sir.
37, my lord.
Of the writ appeal.
Yes, my lord, thanks, my lord.
The top of the page.
Rule 6.1 of the Orissa. Rule 6.1 of the Orissa Aided Education Institution Employees Retirement Benefit Rules 1981, inserted by notification of Department, Higher Education Department FA.
So this applies to aided institutions.
No, my lord, your lordship, that provision. In computing the length of qualifying service of an employee from an aided education institution, all previous services rendered both in any one or more than one aided education institutions as well as in government establishment, except those rendered prior to his attaining the age of 18 years, whether temporary, officiating, or permanent, shall subject to the condition specified in sub-rule 2, 3, 4, and 5 to take into account for the purpose of retirement benefit under these rules.
So this will not apply to you because you want to count the period that you were working in an unaided institution. So this rule will not help you because this rule applies to aided institutions. Now you come to para 10.
Yes, my lord. One fact which is not in dispute, and both the parties have concurred that the petitioner had served 8 years, 6 months and 11 months in Sambalpur University, and his tenure shall be considered as qualifying service, which is short of 1 year and 4 months. Therefore, the issue at hand is, with regard to the petitioner's service at University Law College, Bhubaneswar, where he served for more than 6 years, Learned Counsel for the petitioner, while contending for the summation of the period of tenure of University Law College, Bhubaneswar, while evaluating the qualifying service for the pension, has relied on the case of Dr. Krishna Chandra versus State of Orissa, wherein it was held that considering the rival contentions of the parties and looking into the representation appended to the writ of petition through several annexures and facts narrated herein above, the court finds the petitioner, though all through claimed that he had a long service under different law colleges at Bhubaneswar, affiliated by his university, covering the period from this to this, but from the whole of the representation involving the writ petition.
This you already read, sir. This extracted portion you have already read to us, so we can skip this. This is extract of that judgment which you already read.
Yes, madam.
Now come to para 11.
For the above disclosure, it appears that the aspect of petitioner continuance.
This is all within the quotation, sir.
Yes.
This is all within the quotation. You will find it italics.
11.
This is also part of that judgment which is being quoted, sir.
Yes, my lord.
I want you to come to para 11 of the impugned judgment.
Yes, ma'am. From the above mentioned paragraph, it is clear that Dr. Krishna Chandra, the petitioner, had not disclosed his continuance in 2 spells over 6 years in the constituent colleges of Utkal University, that is University Law College, and he brought it out for the first time through the document appended to the additional affidavit filed on 16/9/2019 during the pendency of the writ petition. Subsequently, this court directed the petitioner to make fresh representation to the Vice Chancellor of Sambalpur University, opposite party number 2, giving details of his period of service, including that of the service in the constituent colleges of Utkal University, along with supporting materials. Opposite party number 2 had clarified that the appointment of petitioner in the unaided and unaffiliated colleges of university and as part-time lecturers, lecturing in University Law College, Utkal University, has not been made against any sanctioned post, pursuant to any advertisement and selection following the mandate of Article 14 and 16 of the Constitution. Minus, a new question has been raised here, minus. That he was appointed person selection since no advertisement was made. And the university appointed him as a lecturer because of the requirement by law. And he served in the university for about more than 10 years for this period that he's been a student. This period is covered as the service of Utkal University under the statute by law. University is appointed. He continued, got salary from the university.
No, it was an aided or unaided?
University by law. University is the...
No. The college, sir. Was it an aided or unaided? This University Law College.
This is all the university itself, not in unaided anywhere.
Sir, don't. If you know it, you say, I know it. If you don't know it, don't hazard a guess. Is this University Law College an aided institution?
An affiliated college of university, friend with the university itself.
Only one more time I'll ask the question. You are a very senior lawyer, sir. You should credit me with understanding the distinction between affiliated and aided. We're not talking of affiliation. We're talking on whether it is aided or unaided. I'm not asking whether it's affiliated or not affiliated. Is this University Law College Aided or unaided?
My lord, aided by the university itself.
There's no question aided by the university, sir.
Because university
Your concept is wrong. Have you ever heard of aided by university?
My lord, university is aided by the government.
Please, I think Mr. Ratha, now you're stretching things. If you don't know, say you don't know. Don't stretch things which you don't know. Don't hazard guesses on these things. You're now getting into the realm of surmise and guessing. Very bad. Very bad to do before a court. On facts, don't start surmising and guessing.
I'm not surmising. May I draw my lord?
Just answer the question. Is it an aided institution or is it an unaided institution?
It is not aided.
How do you know? Okay, if it is not aided, then you go out of the ambit. How is that service?
My lord, it comes lecture law college.
So if it is unaided, then it's knocked out, sir.
No,
you can't count that period.
It is against the sanctioned post of the university, my lord.
You're not, I think you're missing the point, sir. You're completely missing the point. Yes.
And the objection that was raised by the Honorable Single Judge is that I was not appointed against the sanctioned post.
He's not raising it, sir. He is not raising the objection. The single judge is not raising the objection. The university has raised the objection, sir. He is not raising, he's only testing whether the decision is correct or not. The university has pointed out that it was not against a sanction post. That is all.
My lord, that was, my lord, can I have a look, my lord? That was under challenge by the petition in the writ application.
No, but if you have to find out whether you qualify for pension or not, and if you're relying on this rule, which applies to aided institutions, you have to show that Utkal University. No, not university. That is the college affiliated to the Utkal University was an aided institution. University Law College, you should show is an aided institution.
My lord, I have to verify, my lord. I'm sorry, my lord. Your lordship has put me a question. I need little homework for that, my lord.
No. It's unaided, sir. It's clearly. Opposite party number 2 has clarified. Just come to page 40. Read that carefully, sir. Para 11.
Yes, sir.
Page 40.
Para 11.
Page 40. Come to page 40.
Yes, my lord. I'm at page 40. That law college.
Opposite party number 2 has clarified. Just see that. Opposite party number 2.
Opposite, given details of the period of service, opposite has clarified that the appointment of the petitioner in the unaided and affiliated college of university and part-time lecturer, lecturer in university law college.
That is only the second part.
Yes, madam.
Not made against sanction post is only a second part, but the first part says it is unaided.
Minus, I'm coming second and third part. Utkal University has not been made against any sanction and.
That's the second part, sir.
Yes.
First is unaided and affiliated college.
My lord, in that event, the university law college period may be, even that is a student, but the period of service rendered against the post of Utkal University as a lecturer and professor of Utkal University, that cannot be a student, my lord.
Because they are talking only Utkal University here, sir.
My lord, there is a law college of Utkal University. And there is also an affiliated college to Utkal University, that is where he worked. But the objection raised by us that lecturer in University Law College, Utkal University, has not been made against any sanctioned post pursuant to any advertisement.
It's unaided, sir. That part you're missing. That's inconvenient to you, so you're missing it out. Where is this additional affidavit to be filed?
My lord, the question my lord has put is about unrelated agent. I need to give instruction to matter, my lord, so that they can satisfy my lord. Only 2 to 3 days time, that will be all right.
This entire time period is given. One 150. This computer page is completely. It starts at 157. Service recorded.
May I press page 17 for a moment, my lord? Paragraph 13, 14, and 15, my lord.
Actually, your annexure 5 clearly sets out what the facts are. Annexure 5 is that preliminary counter affidavit.
Annexure 5, my lord.
Yeah, to the writ appeal. And you come to running page 155, sir, para 9.
Yes, my lord. 151.
All these are unable. Every one of them is unable. Sambalpur is a public university, so you can't count it back.
By Sambalpur University, my lord, that control of affidavit with the Sambalpur University.
Yes, para 9 if you read.
That the deponent respectfully submits that the petitioner do not possess the qualifying service of 10 years, inasmuch as his whole time was not retainable in public service. He was appointed temporarily on monthly consolidated wages for a limited time in non-pensionable, non-aided establishment with break in service.
This is the problem. This is the real problem. Therefore, you're not eligible to count that service. It now becomes clear abundantly.
My lord, can I have a look to, as I was submitting my lord, can I have a look to that page 75, that read application, that page, what I have offered, my lord, can I have a look to? I was drawing my lord's attention to the statements made by the petition, the writ application itself at page 1, where he has described that he was appointed pursuant to the advertisement and being selected. Page at page 78, my lord.
Yes.
Paragraph 13. That it is respectfully submitted that the petitioner, on the basis of open advertisement published by the Sambalpur University and after facing a rigorous recruitment process conducted by the university, he was selected for the post of principal in which he sought from.
So we are not concerned about your Sambalpur University. In Sambalpur University, only served 8 years and some months.
Yes, ma'am.
Right. You want to add 6 years of service in Utkal University.
Yes, ma'am. My
colleges.
That is.
You want that 6 years to be added?
Yes, ma'am.
So the controversy is not about Sambalpur University.
Paragraph 14, my lord. That while continuing as such, again pursuant to another open advertisement published by the university for the post of professor, and he was fulfilling the terms and conditions of the advertisement and other eligibility criteria as laid down in the said advertisement, he was selected in the post of will be joined on this. Then my lord, kindly skip over that.
No, don't skip. That's the most important part. You're skipping over that. Please read that carefully. Therefore,
and when selected the post of while he joined and continued up to 13 till the date of his superannuation. Therefore, the petitioner has 8 years, 7 and 9.
Why are you running over that, sir? This is the most important part. This you're skipping over.
No, minus thereafter.
Please read carefully this. Therefore, please read that carefully and slowly.
And again, the person eligible. Therefore, the petitioner has served for a total period of 8 years, 6 months, and 9 days in Sambalpur University.
1 minute, stop here.
Yes, ma'am.
So just put this on the corner.
That they accepted.
1 minute, sir.
Yes.
Sambalpur University, 8 years, 6 months, 9 days. Correct?
Yes, ma'am.
What is the qualifying service for pension?
10 years.
So Sambalpur University, 8 years will not help you get pension.
Yes, ma'am.
So without all your service in Utkal University affiliated colleges being counted, you are not eligible for pension.
Yes, ma'am.
Now read.
Now, prior to joining in Sambalpur University, the petitioner had served in affiliated law college of under Utkal University and University Law College, Utkal University, with effect from 82 to 2004. That is for a total period of 22 years, 5 months and 15 days. The details of the service rendered by the petitioner in different law colleges and in Sambalpur University are being reflected through various experience certificates which has been issued by the various university. A copy of the Annexure 6 and 3 that it is responsibility that at the time of every stage of selection, either in Utkal University or in Sambalpur University, the condition precedent was teaching experience in law college.
That's all neither here nor there here. The only question therefore is your service in all these colleges affiliated to Utkal University, was it in aided colleges or unaided colleges? And the categorical statement made is that these are all unaided colleges. So what is going against you is that since these are all unaided institutions, the service rendered by you in an unaided institution will not qualify for pension. This is the only issue, nothing else.
I have given a detailed list, my lords.
List is there, sir. We have names of all the colleges.
Yeah.
The only thing is, are those colleges aided or unaided colleges? The categorical finding is they're all unaided and therefore doesn't qualify for pension.
Your Lordship, if the Utkal University Law College of Utkal University is to be aided one,
you and I cannot make it aided, sir. If it is unaided, it's unaided. We cannot read. This is not some statute where the word aided should be rated, unaided should be read as aided. It's a fact. It's not a question of interpretation. All right.
Now, your Lordship has told me.
No. It's all clear, sir. No, the whole
that has to
it has taken, thanks to our poor understanding, it has taken us such a long time to get the facts. We have to blame ourselves that we took so much time to understand the full facts.
Minus the services rendered under the Utkal University is governed under the provisions of Utkal University statute.
Correct.
Under the Utkal University statute, any person working under Utkal University, that service is to be counted for the purpose of pension.
Only if it is aided institutions.
No, that is for the Education Act, my lord.
Yes.
Utkal University is not governed under the Orissa Education Act. Utkal University is governed under the provisions of the university manual rules framed by the university itself, approved by the governor.
All right.
Therefore, my lords, if that Sambalpur University also is governed under the university framed by the state government.
Yes. Respondent Sambalpur University was justified in declining the prayer of the appellant from retired as a professor in law of the PG department that he was entitled to pension. Full stop, paragraph. The aforementioned writ petition was the second round of litigation before the learned single judge. Full stop. Initially, the petitioner had filed writ petition civil. (19656) of 2015. which came to be disposed of in 1410 on 14th October 2019. Bracket hereafter. Dr. Krishna Chandra Jaina versus State of Orissa -1 UC bracket. Directing the appellant to make a fresh representation to the VC, Vice Chancellor bracket VC of Sambalpur University. Full stop. The appellant then made a representation on 23rd October 2019. Full stop. After considering it and giving a hearing to the appellant, and the order was passed on the basis of the resolution of the syndicate dated 19th September 2020 that his representation was rejected. Paragraph. The case of the appellant was that he had served in the Sambalpur University, first as a principal of an affiliated LR Law College, and later as professor in the PG department for a total period of 8 years, 6 months, and 11 days. Full stop. Prior thereto, he had served in various colleges affiliated to the Utkal University, for a period of 6 years, 3 months, and 21 days. So if both these periods were counted together, he would have completed a total tenure of 14 years, 10 months, and 2 days, and was therefore eligible for pension as he had completed more than 10 years of teaching. Paragraph. Reliance was placed by the appellant himself on 3 statutory provisions. That is clause 260 of the Odisha University First Statute 1990, which talked of single quotes counting of past service, and which read as under, take from page 36. So the other provisions were Rule 47 of the Orissa Civil Service bracket Pension Rules 1992 and Rule 6 bracket 1 of the Odisha Aided Educational Institutions Employees Retirement Benefit Rules 1981, which read as under, take from pages 36 and 37. Paragraph. For the purposes of clause 260, one of the categories of the institutions where an employee had to render service for the purposes of single quotes qualifying service for gratuity and pension was single quotes any college affiliated to any university of the state and aided by the state government, unquote. On the appellant's own showing, and as indicated by him in his written notes of submission observations made before the learned single judge, forming part of the record, he served in several institutions affiliated to the Utkal University between 5th July 1982 and 21st December 2004. And these included the Capital Law College, the Jagjeevan Ram Law College, the GNM Law College, the University Law College. First as part-time lecturer and then a lecturer. The appointments were not on regular basis against sanctioned posts and therefore did not qualify for pensionable service. Paragraph. The learned single judge has in the impugned order. Noted the stand of the Sambalpur University that the appellant's claim was being rejected on two grounds, namely that his service in colleges affiliated to the Utkal University, including university law colleges, was service in an unaided institution. And secondly, that his appointment was not made against sanctioned posts pursuant to any advertisement and selection. Reference was made to the decision of the Supreme Court of India in P. Bandyopadhyay vs. Union of India, 2019 1 ILR -CUT 641-SC, where it was observed that unless the minimum qualifying service of 10 years was rendered, the employee would not be entitled to pension in terms of the CCS bracket pension rules 1972. Paragraph. Mr. Jayant Ratul and its senior counsel, appearing for the appellant, argued that there was nothing in Rule 260 of the statutes that mandated service against a single court sanctioned posts, unquote, or on regular basis. Full stop. He accordingly submitted that this could not be a ground for rejecting the plea of the appellant for service for pension. Paragraph. A reading of clause 260 of the Orissa University first statutes, which talks of counting of past service, makes it clear that for the purposes of qualifying service, the employee in question had to necessarily serve in a college not only affiliated to university but also single courts aided by the state government, unquote. With Sambalpur University clearly taking a stand that the service rendered by the appellant prior to his joining the Sambalpur University was in single courts unaided, unquote, institutions, the burden shifted to the appellant to show that these were in fact single courts aided, unquote, institutions, that is aided by the state government. Full stop. Despite there being two affidavits of the Sambalpur University in reply to the writ petition, there was no rejoinder filed by the petitioner to dispute the above assertions that the institutions in which the appellant served prior to joining Sambalpur University were unaided institutions. Full stop. In fact, even in the written note of submissions filed by the appellant before the learned single judge, there is no such stand taken by the appellant that he had served in institutions that were aided by the state government prior to joining the Sambalpur University. Paragraph. In that view of the matter, it could not be said that the Sambalpur University erred in rejecting the appellant's representation for grant of pension. Paragraph. The court is therefore unable to find any error having been committed by the single judge in dismissing the appellant's writ petition. Stop. The writ appeal is accordingly dismissed. Yes.
Item number 40.
14th September. Workshop.
All right.
Item 41.
41, 42, 8th memo Sarto Parade.
All right.
Item 43.
43, 14th September.
Right.
Item number 44. Item 44.
No, please dismiss for opposition.
Item number 45.
8th of May, my lord.
All right.
Item 46.
My lord, similar to yesterday's item number 60 and 62, which your lordship fixed to 26th of June, 27th of June. Arising out of the same common order, all these writ appeals were.
Give us the numbers, sir. List along.
Number is WA 80, 85 and 88. Those two cases were listed yesterday.
88 on 27 June.
Yes, ma'am.
All right.
Okay. Item 47.
47, 11th May.
All right.
Item 48.
8th of May, my lord.
All right.
Item number 49.
49, 8th May.
Right.
Item number 50.
May I please, your lordship? My lord, the financer being the appellant has challenged the order of Honorable Single Judge at page 42, your lordship, wherein Honorable Single Judge, while dictated that the writ is not maintainable in para 5.
Similar order, we passed the other appeals have been filed against similar orders.
Yes, sir.
Where is that order?
I do not have that.
In your own appeals, we have passed orders, sir.
Yes, sir. Lordship.
And you don't have copies. Even that we have to help you.
Absolutely, man.
If I were you, sir, I would my first submission would be against a similar order. Your lordship has passed this order. Would you not say that?
Yes, sir. Lordship.
So what should we do?
Issue notice in that application, and your lordship issue notice in that application, and please to stay the impugned order, my lord. I could not able to bring.
Why? Why were you not able to? It's your own matter, no?
Yes, lordship.
So you remember the date, you remember the number, nothing. You yourself have filed. This is remarkable, sir. You have an order in your favor, you don't have the copy of the order, you don't know the number, you don't know the date.
I will provide, my lord. I will provide within.
We'll pass it over.
Yes, lord.
Item 51.
51, my lord, 20th July. Laboratory technician, 20th July.
I am for the petition number 1, my lord. Direct to copy.
Respondent number 1.
OP number 1.
Respondent. This is a writ appeal, so it's a respondent number 1.
Read copy I have not received that.
Item 52.
I worked at 14th September.
Item 53.
53, old pension, 25th April.
Item number 54.
54 also old pension, 25th April.
Item number 55.
May I please, your lordships? My lord, on the similar order, my lord has already allowed the writ appeal, permitting the petitioner to file the petition.
बस पढ़ लेंगे तो चलिए
The common order.
Yes, my lord. Same order, only here the date of order was inadvertently typed. Therefore, I have filed the IA for correction of that order, my lord. Annex 2.
IA for correction of order. What IA?
My lord, the date of order was wrong, inadvertently typed as 28/11/2021, page 16, which needs correction. My lord, actually the date is 28/11/2022. Therefore, Annex 2, page 21, the IA was allowed, page 23, my lord.
That's anyway by the single judge. All right.
The opposite parties are admitted that we are the my lord, employees of the FCI, but the Honorable Single Judge has held that there is no semblance. My lord, page 17, para 3. Even though petitioners claim to be guided by the pension scheme of the Food Corporation of India, unfortunately, entire reading of the pleadings of the
All right. You say in para 3 of the impugned order, the learned single judge has observed that there were no materials to establish that, open quotation, the petitioners are the recruitees of the Corporation of India, and being direct recruited by the FCI should be governed by the FCI employees' terms and conditions, unquote. It is submitted that from the pleadings in the writ petition, even the respondent, opposite parties, did not dispute that.
Para 4 and 5 of their counter, page 67, madam.
That the appellants were direct recruits of FCI. Paragraph. In the circumstances, while permitting the appellants to file a review petition to draw the attention of the learned single judge to the above pleadings in the writ petition, the court declines to interfere at this stage. The writ appeal is disposed of in the above terms.
Obviously.
Madam, we are for the Union of India, madam.
All right.
Item 56.
56, 57, 8th में शर्त पड़ा.
Item 58.
None appears dismissed.
Item number 59.
I am appearing on VC. I am appearing on VC, my lord. This is a promotional matter wherein the Honorable Single Bench has dismissed it on the ground of delay. It has shown delay of 12 years, but it is of 9 years from the date of passing of the final order of the. I pray I will remove the defect, and as I have already taken time on 4th by saying that I am very serious in diabetes and this sugar level. I will do it by next week. If in the meantime, I will definitely remove the defect.
Now, what is the delay, sir?
Delay of 9 years is there. It has been written in annexure page 11 and paragraph 5. Kindly look at the dismissal order.
No, dismissal order is where, sir?
This annexure 1 at page 11, kindly be looked into.
Annexure 1?
Annexure 1 at page 11.
Which is the item number?
It starts from page 8.
You are appearing WA 167, sir.
Huh? On behalf of my junior.
What? Which is the writ appeal number? Give us the writ appeal number in which you are appearing.
167 of 2023.
Dr. Sunita Tripathi.
Yes, sir.
Annexure 1 Is copy of
Copy I have not supplied.
Oh, they've scanned 22. 167 of 22 has been scanned. What is the explanation for the delay?
Delay is for mental illness and moving the OHRC, and it has been plausibly and properly explained.
Where? Explained where?
Explained in para 9 of the writ petition and also in facts of the case of the writ appeal, para 2. Para 3.
Para 9 of the writ petition. 1 minute. Let's see para 9.
Also in writ appeal also I find the facts, it has been shown. Order was passed in 2013.
So this is not a proper explanation, sir.
In other paras also I have said that because the person who is precluded from inquiry, he took up OP number 4. He was precluded by OHRC.
No.
Held it from
This is about delay in coming to the court, sir.
That is explained, my lord. Properly.
No, we are looking at it, sir. Para 9.
My lord.
The explanation is not convincing, sir.
It is spread to other paragraphs, but if your lordship kindly come to writ appeal para 2, facts of the case, then your lordship may come to sub para 3.
Let's see that, sir.
Petitioner was hoping that the litigation would come to end. That is in 2013, where the final order of promotion was passed on humanitarian ground, not on the development, mental depression. After passing of the impugned order annexure 3 at page 53 of the writ application, which incapacitated her to move this honorable court, being afflicted with mental illness.
What is the document? What is the document you placed in record in support of this, sir?
I have not placed any document, but the OHRC has barred the OP number 4 not to take up the case.
That is a different issue. But OHRC, that's a different issue. OHRC passed that order in 2012 itself, correct?
12 itself, correct?
No, we are now on sir, if you will permit, we are now on the delay of 9 years in filing the writ petition.
My lord. The person who was precluded, he conducted the EA.
That's on merits, sir. That is on merits. That is on merits.
No. I'm telling only one word. In 2013, they passed the order. That was not culminated in the merit, and merit under annexure 4, she is entitled to. So when the promotion was not given, she entered into a mental depression.
What is the document to show that, sir? Because it's 9 years. You have to have some document to show this.
That is why I will file the document if any required.
No, not at this stage. I'm sorry. When you file the writ petition, you should have produced those documents, sir.
Okay, sir. I have not filed it. Take it for granted. Now, the Supreme Court latest judgment says that under Article 226, judicious discretion has to be explained. If properly explained and plausibly explained. This is
so the word properly. For the word properly, sir, we want you to produce some documents. Otherwise, we cannot properly exercise our discretion unless you properly produce documents.
Properly means these.
Properly means you produce documents properly, then we will consider it properly.
Allow me some time, 1 month only.
No,
because
not
I
now,
will show
not
you
now, not like this. When you file the writ petition, you should have properly produced documents. Then the single judge could have properly considered it.
No, the single judge has not entered into it. It says laches only. What laches? Delay and laches.
That's right. Even we are only on that ground, sir. We are only on that ground.
Yes, I have that I have taken the paragraph which affidavit that I am not in a position mentally to take up the case.
That is not good enough, sir. Some documents have to be. Otherwise, it becomes all self-serving, correct?
Self-serving in filing an affidavit, we come to this court, not in ordinary hands. Your Lordship may understand one thing. If the impugned order does not affect any third party, this court has a power as a constitutional court to enter into anything. Allow me only 1 month time. I will because I have taken time on 4th on the ground of my swelling of feet, and
now we will not. Yeah, we'll stop it here itself, sir. You said the present writ appeal is directed against an order dated.
No, kindly, my lord, kindly allow me.
An order dated 9 January 2023, passed by the single judge, dismissing writ petition civil 36192 of 2022 on the ground of delay in latches. Paragraph. The prayer in the writ petition was for a direction to the Vice Chancellor of the Berhampur University to grant the appellant promotion to the post of lecturer (SG/reader) with effect from 27 June 2001. And thereafter to the post of professor with effect from 27 June 2006. And to set aside an order dated 31st August 2013 granting promotion to the appellant to the post of lecturer bracket selection grade with effect from 27 June 2002 and reader with effect from 27 June 2007 on special humanitarian grounds. Another prayer in the writ petition was for quashing and report dated 15th April 2013 submitted by the then VC cum inquiry officer bracket impleaded as opposite party number 4. Rejecting the representation rejecting the allegations made by the appellant in her representation. Full stop. Paragraph. Since the writ petition was filed on 22nd December 2022. The appellant was obliged to offer an explanation for the extraordinary delay of nearly 9 years in approaching the High Court for relief. Full stop. Counsel for the appellant has drawn attention to para 9 of the writ petition, where the explanation offered reads, single quotes, like pursuing the matter wrongly before OHRC on ill advice, developing mental depression, /instability, /imbalance during the interregnum period, born out of inflicted mental and financial irreparable damage, /loss, an injury by OP number 4 and his friend, single quotes, Misra, that left acute, deep and indelible rancors forever in the mind of the petitioner over the years, and for COVID period in OHRC disposed of on 17/8/22, unquote. Paragraph. When asked whether there was any document to support the averments concerning the appellant suffering from mental depression, counsel for the appellant answered in the negative and sought time to produce some document at this stage. Full stop. In the considered view of the court, such document, if available, should have been produced along with the writ petition. Full stop. Paragraph. The court finds that indeed the appellant had approached the the OHRC, Bhubaneswar, with OHRC case number 1345 of 2012, in which an order was passed on 22nd November 2012, requiring the Chancellor to deal with the representation made by the appellant. Seeking voluntary retirement from service. It was further mandated therein that the allegations made by the appellant should be inquired into by an independent agency. Paragraph. Since this order was passed on 22nd November 2012 itself, it obviously did not help the appellant as far as the explanation for the delay in filing the writ petition was concerned. Stop. It will be recalled that the writ petition was filed only on 22nd December 2022. Paragraph. Counsel for the appellant then referred to para 2 of the writ appeal, where again it is averred that the appellant open quotation lost her mental balance and went into acute mental depression and illness from late 2013 ... unquote. Stop. This again is without any supporting document whatsoever. Paragraph. In the above circumstances, the court is unable to come to the conclusion that the learned single judge erred in rejecting the writ petition filed by the petitioner on the ground of laches. Stop. Indeed, the extraordinary delay of over 9 years in preferring the writ petition has not been properly explained by the appellant. Stop. For the aforementioned reasons, the appeal is rejected. is dismissed.
I meet clerk.
Come back.
Can take up it because your lordship on my wrong submission, your lordship.
No, 54 is what? Some other matter.
That's other matter.
So let's see that.
But I made a wrong submission that.
All right. Tell us what's 54.
That's my lord, that what has happened in that case, my lord, some period has not worked. And by virtue of my lord's direction, he has been adjusted. And that period, the single judge are directed to pay him salary. That is the. Three dates, my lord. The institution where that respondent was working, that's a block grant school, my lord. Because of that dispute between the villagers, that school was closed. Thereafter, they approved my lords further adjustment. And your lordship were directed further adjustment. And accordingly, in 2019, they were adjusted. So they are claiming salary from 2011 to 2019. The Honorable Singulars are directed for release of their salary.
All right. Notice. There's no contempt yet.
It must no contempt yet.
Okay. Notice on both the appeal and the application. Returnable. 18 July.
My lord, item 50, I may pardon to make a mention. I have provided the order copy, my lord. But here is, sir pointed out some delay, my lord.
All right. Both put down. Is there an IA for delay?
Yes, your lordship. I filed application for condonation.
Put the IA also. Appeal and IA for delayed notice in the same order. 11th.
Here it is directed for issuance filing of requisites within 4 weeks. A shorter time may be fixed, my lord.
2 weeks. Okay.
Yes, your lordship. Deeply obliged.
Item number 59.
59 Satyapada 8th May. 59, 60, 61, 62, 63, 60, 63 Satyapada 8th May.
Item 63.
Up to 63 Satyapada.
Item number 64.
64 my workshop 14th September.
All right.
65.
65 your lordship may call this one next week.
The request of cause for the appellant list on 18th May.
Item number 66.
66 DLR regulation on 25th of April.
All right.
67 same, my lord.
68.
68 rehabilitation 30th September. The 30th August, my lord.
30th August.
Also 610, my lord.
69.
Item 70.
70 job contract 14th of September, my lord.
Right.
71 same, my lord.
Item 72.
72 work charge employee 14th of September.
Item 73.
None appears.
Item 74.
So the DLR employee, my lord, 25th of April.
Right.
Item 75.
My lord, work charge employee, 14th of September.
Item 76.
76, my lord, DO, data entry operator, my lord, 8th of August, my lord. Outsourcing.
Outsourcing.
Item 77.
I am for the petition, my lord, appellant, my lord. The impugned order under Annexure 1 passed by the Honorable Single Judge. The confirming order under Annexure 1 and Annexure 5 was challenged by the respondent 1 in the writ petition, and the writ petition has been allowed, holding that the regulation court has no power to decide the case. Annexure 1, the ordering person. My page 12. My case was allowed under Annexure 5. That they are not the scheduled tribe person, so they are evicted. Annexure 5 original court allowed my case. They filed appeal. In Annexure 1, appeal was dismissed. And the London Single Judge said that it can not be adjudicated by the regulation court. The provision is section 7E, civil court is bar of regulation.
All right, we will say notice returnable. 17 July. Notice on stay.
Item number 78.
May I please? Page 24 is the impugned order annexure 2, my. Therefore, the departmental proceeding has been quashed and direction has been given for release of retirement benefits with 6% interest, my lord. Page 32.
Yes.
This departmental proceeding, he has challenged this before the tribunal and it was stayed at his instance for 7 years.
Is superannuated now, sir?
By superannuated, that is admitted fact, there is a criminal case is pending. It's rule 66 of the pension rule is a bar. Let me see the rule 66. Rules during pendence of the criminal case, he is entitled only to provisional pension.
All right, notice returnable. 17 July. There should be a stay of the impugned order here.
Note 79.
Not 79 and 80 is data entry operator, my lord, 8th of September.
8th of August.
I'm sorry, 8th of August. Great.
Item 81.
My lord, is the electrician death, my lord. The appellant are the widow and his son, my lord. The honorable single judge ordered only, my lord, 2 lakh rupees.
Correct, that's correct. So we're not interfering in those orders because remaining you have to go for civil remedy.
Yes, my lord. For higher amount,
Counsel for the, you say the present appeal is directed against an order dated 3rd January 2023 of the Lord Single Judge, disposing of writ petition civil 23491 of 2010, filed by the present appellates. Seeking directions to the respondent be awarded compensation of rupees 3 lakhs along with interest at 12% per annum from the date of the accident. Paragraph. The appellants are the widow and son of deceased Goranga, alias Bairagi Jena of village Panakuri, district Jashpur, who is stated to have expired after coming into contact with a live electric line on 10 June 2021 in the morning hours while cutting bamboo canis. Stop. The learned single judge noted the stand of the electricity department that the allegations that the deceased died after coming into contact with the live wire belonging to the department was not proved. The learned single judge noted that both the inquest report and the postmortem report confirmed that the death was as a result of the deceased coming into contact with the live department, the live wire maintained by the department. In the circumstances, the learned single judge ordered compensation of rupees 2 lakhs to be paid, noting that there was no proof of the income earned by the deceased at the time of his death. Interest at 7% per annum has also been awarded. Paragraph. Considering that the appellants had prayed for compensation of rupees 3 lakhs, whereas the learned single judge was awarded rupees 2 lakhs together with interest at 7% per annum, the court sees no real ground made out for interference with the impugned order of the learned single judge. The appeal is accordingly dismissed. Delays condoned.
Item 82.
82, 83, 84, my lord, 8th of August. Data entry operator.
Item 85.
My lord, 85, I will remove the defect, my lord. 3 days time may be required, my lord. I'll file also application for condonation of delay, my lord. 3 days time.
I am appearing for the respondent, my lord, by filing this writ appeal, that taking time before the learned court below, that since the writ appeal is pending, so this matter cannot be proceeded with. And I am running since 1999 to get my right established, my lord. Though I have purchased the properties.
My lord, a fraudulent transaction has been done.
This is the fourth round litigation.
Tribe persons, my lord. Only
This is
3 days time to remove the defect, my lord.
No, it's only dismissed on delay.
Yes,
not
my
on
lord.
merits.
Not on merit.
CMAPL was filed due to non-compliance of the peremptory order passed by this honorable court in the writ petition. And the CMAPL was filed after 7 months. Deliberately one after another. This is fourth round litigation.
No, but what was the peremptory order in the writ petition?
Permitted order was that to serve a copy on the opposite party within certain period, my lord. My lord, after lapse of 2 days, my lord, I have offered my brother a copy, and he said that no, since the matter is dismissed, you send a notice a copy to my client. Thereafter, I send a copy to my client.
The petition be decided on merits, he can give you cost.
Yes, my lord.
Your lordship fix a date.
Yes.
I humbly pay your lordship. Your lordship fix a date.
Yes.
Because the lady is being harassed.
Have you filed a counter?
Yes, my lord.
Pleadings are complete.
No.
No counter is required, my lord, because previous records are already there.
So it's up to you. If you want to file, I'll give you a date. If you
Your lordship
file,
fix
no
a
further
date. Only I pray your lordship fix a date so that the matter can be decided on.
It is seen that the impugned order has dismissed the appellant's CMAPL. Impugned order dated 3/11/2022 of the learned single judge has dismissed CMAPL 351 of 2022 on the ground that there is an unexplained delay of 209 days in filing it, seeking recall of an order dated
8 December 21.
8 December 2021, by which 28 December.
My lord, 8 December 2021, directed to serve the copy, my lord.
No. So the recall must be of 28 December.
Yes,
My lord, my lord.
28 December 2021, by which writ petition civil number 7385/2020 was dismissed for non-compliance with an earlier order dated 8/12/2021, by which the counsel for the appellant had been asked to serve counsel for the opposite parties.
Number 3.
Opposite party number 3, a copy of the writ petition. Full stop. Not 2812, 14/2/22, not that 2812 paragraph. It is seen that on 8/12/2021, the learned single judge had specifically ordered that a copy of the writ petition should be served on counsel for opposite party number 3 within a period of 7 days hence, open petition, failing which the writ petition shall stand dismissed without further reference to the bench, unquote. It appears the copy of the writ petition was served beyond the aforementioned period of 1 week.
Not solved, my lord. They taken a ground that they tried to solve, but it was not solved.
No, 14/2/22, receipt showing service of copy.
No, my lord. That's not, they have not solved because I was the counsel there.
Even today, you don't have a copy of the
No, no.
My lord, I have sent it through post, my lord.
Either you give it to him right now.
Yes, I'll give you that.
Right now.
Right now, I am giving him a copy.
That is the crux.
All right.
He refused to accept after it said that my junior is involved, therefore you send the copy.
By that time, the writ petition was already dismissed.
I'm
So
sorry.
based on the above peremptory order, the writ petition stood dismissed on 14/2/22. Paragraph. As regards the delay of 205 days, the orders passed by the Supreme Court of India in the COVID-19 matter would inure to the benefit of the present appellant. Would stop in that. In those circumstances, the said delay ought to have been condoned by the learned single judge. Paragraph. Having heard learned counsel of the parties, the court passes the following directions. 1. The impugned order of the learned single judge dismissing CMAPL 351 of 2022 is hereby set aside. 2. The delay in filing the aforementioned CMAPL 351 of 2022 will stand condoned and the CMAPL is allowed on merits. 3. As a result, writ petition civil
Seven 7385/20.
7385 of 2020 will stand restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 3rd July 2023. Or if the respondent herein so chooses, they may file parawise reply to the said writ petition on or before 23rd June 2022, and if so filed, it will be open to the appellant herein to file a rejoinder thereto on or before 3rd July 2023. Next, the learned single judge is requested to proceed with the hearing of the said writ petition on merits thereafter and endeavor to dispose it off as expeditiously as possible. It is made clear that no adjournment will be granted to either party for any of the above purposes.
Obliged.
The writ appeal is disposed of in the above terms.
Item number 86.
My lord, copy solved, my lord. Copy
Yes.
solved.
You say it's noted here that copy of the writ petition is today been served upon counsel appearing for the respondents.
Obliged.
Item 86.
86, 87, my lord, rehabilitation assistance, 30th of
August.
Yes.
Item 88.
88, my lord, vigilance proceeding promotion during the pendency of vigilance proceeding, my lord, 11th of May.
Right.
89.
89, old pension rule, my lord, 25th of April.
Right.
Item 90.
90 and 91, my lord, 49, my lord, work charge employees, my lord.
Right.
For admission, item 92.
A big apology. Item 73. I was on my legs, so I have missed it. Your Lordship, I dismissed it for default.
Tell us about 73.
My Lordship. Item 73. There's some defects here, Lordship. I have to remove the same. I filed some illegible copies of the annexures, which have to be brought on record, Your Lordship.
All right. We said list on 22nd June. Defects be cured in the
I'm grateful, Your Lordship. I beg apology, Your Lordship.
Item number 92.
Your Lordship, item number 92, my lord, I'm appearing on VC, my lord. My lord, this is a covered matter, Your Lordships. Your Lordship have already passed orders, my lord. My associates will just hand over the orders, similar orders, my lord. My lord, the only, my lord, I must say I have taken the liberties of making correction with pencil, my lord. My lord, if I just one thing I wanted to bring to your Lordship notice, my lord, I've made the changes wherever it's appropriate. My lord, if turns over the page, my lord, at page 4, para 4, in those cases, my lord, a counter has been filed. Now, my lord, in here, this case, my lord, to the best of my ability, I could not, it is a transfer brief, I could not find, my lord, an affidavit, so I have made it, but it's completely covered, my lord.
All right. So we'll take out that whole paragraph for the reply.
My lord, my lord. My lord, because that was one of the grounds that your Lordship decided. It can be said that in similar matters, or your Lordship can take it off, my lord, as your Lordship pleases. Because my lord had disposed of the other matters on the ground that in the counter that they have said that it's a contribution.
Right. All right. We'll just say that 1, 2, and 3 you repeat. 4. You see, in similar matters, the court has, in a similar matter, the court has been ordered 16/5/2022 in repetition civil 8350/2016, bracket Messrs. India Metals and Ferro Alloys Limited versus State of Orissa. Clarified that the language used in the letter dated 16/2/2016 is only a request by the opposite parties to the petitioner, which cannot be characterized as a demand or in the nature of a compulsory exaction of money in the nature of tax. So a similar clarification is issued as far as the present petition is concerned. No further directions are required to be issued. The interim order stands vacated. The petition is disposed.
Grateful, my lord.
No, 93.
The counter is ready. Let's only grant one time.
Mr. P.K. Manthi, appearing for the opposite party, states that the counter affidavit will be filed positively within a week from today. To join the FNA for the next date. Is there an interim order?
No interim.
No interim. Yes. 18th July.
94.
And 94 Lordship, today I have received counter. 3 weeks time to file rejoinder.
Rejoinder to be filed for the next date based on 23rd August.
Lordship, interim order.
Order to continue.
Item number 95.
Lords, this is a problem in that litigation. That the villagers challenge the initiation of the disease proceeding, consequence upon they acquire the land for the purpose of the industry, for the opposite partner 6 Vedanta for construction of ash bond. My allegation, Miller, entire 67 acres of land has been acquired by following deregister proceeding without offering a chance of hearing, Miller. Today,
Have you seen this counter?
Yeah.
Have you seen the counter?
My lord, I have to file a return.
All right. Today, Mr. P.K. Nayak, learned counsel appearing for opposite party number 5, respondent number 5. Opposite party number 5 is handed over a counter affidavit. Counsel for the petitioner seeks and is granted time to file rejoinder before the next date. July.
25th July.
Item 96.
Millard, in this case, I am for the petitioner Millard. as per your lordship's direction, dated 9th January 2023, only the BDO Bhadrak has completed the execution work of that road out of total amount of 22,80,000, only 6 lakhs. 6 lakhs of rupees, which covers about 165 to 170 meters. Rest of the parts remain dilapidated position. Your lordship may kindly have a glance on para 4 and 5 of my.
1 minute. We called for an affidavit from the BDO.
Yes, we have filed the affidavit and the BDO is present, your lordship.
And so far the direction given to state government is concerned, they have not complied, Miller. In that order, so far the direction is given.
Your lordship, kindly see para 5 of the counter affidavit filed on 17th April. So far as the street light is concerned, my learned friend is insisting in a particular village, a small hamlet. He wants that the street light. It's a very small hamlet. That is my instruction.
Small hamlet, Miller.
And it is always submitted that in the letter number so and so, it is stated that there is no provision for installation of extra street lights on the village of Gram Panchayat. There is no provision. If we will allow in one village, then entire lakhs of villages in the state, they will demand for street light in these are all small hamlets in Gram Panchayat. Other works, road works already completed. Your lordship can ask the BDO. BDO he also admits.
Out of 6 lakhs of rupees,
he wants that the village should be converted to a urban area. That is, it's a very remote village. Your lordship, kindly imagine if this will be allowed, then other villagers will ask for the same relief.
There is no, but even here the road has not been completed.
Yes, road is completed.
No. It is bottom of page 4, bottom of para 4. The rest part of the road will be completed after release of fund from the government.
We have completed a major portion. Some we have asked.
No, you are only, V's means PR and DW department is also you only, sir.
Yes.
But so when will you release? See, he's now not committed to any timeline now because he says funds have to come from the department.
That your lordship may kindly imagine.
Now the new budget year is started. Now you can't say no funds.
No, because that is for road purpose only. We will give.
When? See, we had asked you to specify the timeline.
Your lordship may kindly give me some time. I will seek instruction from the government itself. That what is the provision
in
for budget.
4 of the affidavit of the BDO submitted today. It is stated in para 4 that till date 170 meters of the road work along with drain work at village Kalai has been completed, and that the remaining part of the road will be laid, open quotation, after release of fund from the government in PR and DW department, unquote. In other words, the affidavit is non-committal as to when the work of road laying will be complete. To stop further, it stated that as per the letter dated 27 July 22 of the PR and DW department, open quotation, there are no provision for installation of extra street lights in one village of a Gram Panchayat, unquote. Paragraph. In view of the above stand of the BDO, a direction is issued to the Principal Secretary, PR and DW department.
My lord, director PR.
Or director
Panchayat Raj.
File a supplementary affidavit.
Yes,
before the next date, indicating therein that funds for the remaining part of the road construction in the above village has in fact been released. Full stop. Further, a clear stand as to installation of street lights on the said road shall be indicated in the said affidavit. Stop. Paragraph. It is noted that the petitioners have also filed an additional affidavit, which is also taken on record.
Lord.
List on PN. July.
Lord, the personal appearance may be dispensed.
The personal appearance of the BDO is dispensed with.
Lord, we can understand the anxiety of my learned friend because it is his own village. But if we, your lordship may kindly say, if you
it's okay, he should do that for his village.
No, but then many other villages will come and ask for the same relief.
So why don't you contribute to street lights?
Yes, let him contribute.
He is
We'll ask
a
him
senior
to put
advocate and doing
your name also in every street light.
that. I will
Contributed by
instruct
Mr. Parida.
I will instruct the government that he will put his name. The government will put his name that he has contributed this much.
You contribute 1 light.
If he will contribute 10 lights, I will contribute 1 light.
What do you say?
My friend is saying like that.
How many lights are needed in that road?
Millard,
How many lights?
Corewards, big village, Millard.
No,
There
no,
are
no.
big
In that
village.
once the
Why
road is
are you saying
complete,
that? The field
It is
where it is
I think every 15 meters is
Hamlet.
1 light is more than enough.
It is a hamlet.
Yeah, every 15 meters, you find out how many lights.
minimum 40 lights.
Let my learned friend say, has he seen any other villages where in remote villages there is street light?
Model village.
If one village will seek such a
Out of
then other
60
lordship has to see the parity. Other villagers will come and say that in our village there should be.
He's got those petitions lined up. Once this is done.
Once your lordship will open the Pandora box, then others will come for the same relief. Yes.
All right.
Millard, minimum 40 lights sufficient.
No, that cannot be.
60,
That is-
65
Anyway,
can
let them
be-
indicate. Meanwhile, you think of whether you want to install some lights. Now there are solar lights, all kinds of alternatives are there. Just explore it. All right.
Item number 97.
Well, this 97 initially previous lawyer withdrew his power and I had filed a CMPL which was restored by your lordship. Your lordship, I have appeared on 17-3, but my name has not been indicated for the petitioner. Your lordship may direct the registry to indicate my name. Your lordship may call any other day. Because I had not seen the brief, my lord. Yesterday I missed the list because my name is not there in the list.
Mr. A.P. Bose's name be indicated for the appellant in the cause list. All right. List on 27 July.
Both the matters, my name may be indicated.
See, the fact is that you're able to appear even without your name being.
No, my lord. I missed the list. Today morning, I got the information from the client that it is listed.
All right.
Premiers, I'm appearing for what? A copy of the writ appeal may be sought to me.
All right.
I'll sub, my lord. 2 matters, I'll sub 1 copy.
All right. All right.
Item 98.
This is that matter, your lordship remembers, where the mutation case was, they declined to proceed with the mutation case because the vigilance had seized the records. Your lordship had directed them by order dated 22/11/22 to find out the position of the vigilance case. Now they have filed the affidavit, paragraph 2. It is in the court. The cognizance has been taken. So what I pray, my lord, subject to your lordship's consideration, the Tahsildar may requisition the record because that is not connected with the charge. And within a particular time, dispose of your lordship and return the necessary.
I appear for the respondent 1, my lords, the Odisha vigilance, my lords. I filed an affidavit, my lords. I have got a submission, my lords. Your lordship may permit the petitioner to get the certified copy of any other documents which are relevant for the purpose of immutation matters. The reason being of the submission, my lords. Now, the next date is for a consideration of the discharge application by the learned special judge vigilance, my lords. All those documents has to be referred to.
No, I have no objection to get.
So what I suggest, if lordship permit, my lord, the background in this case, in the vigilance case, 8 out of the 8 accused persons, 4 accused persons are the brothers and relation of the present petitioner. No, he is not. That's why say lordship permit me. Out of the 8 accused persons, my lords, the 4 persons are the brothers and relation of the petitioner, my lords, and the appellants, my lords. And my lords, they have the one common ancestor, one Manmat Nas sale, my lords. They executed the sale deed pertaining to the forest lands, my lords. Now, my lords, all the lands records and all these things have been seized and in the Malkhana of the London Special Judge Vigilance Plots. Now, lordship permit the appellants to get the certified copy of any documents because voluminous documents all may not be relevant for the purpose of mutation. Lordship permit them to get the certified copy and so that both the courts.
All right. I have no objection to get the certified copies, but I should know because what the record he needs.
You inspect.
So I'll get. So what I beg to submit, Lord,
will permit you to inspect and then obtain certified copies.
Certified copies of the documents, and that may be granted within a particular time, and the Tahsildar may be directed to act upon those certified copies and pass necessary.
All right. An affidavit has been filed by the Superintendent of Police Vigilance, Cuttack Division, on 9th March 2023 stating, inter alia, that the record of TR case number 8 of 2018 and all documents seized by the Vigilance Department are kept in the Malkhana of the Court of the Learned Special Judge Vigilance in Cuttack. Full stop. The case was posted on 18 March 2023 for appearance of the accused and for hearing of discharge petition. Court is informed today by Learned Counsel for the Vigilance Department that it is now listed on.
Big ordinance.
When is it listed?
I couldn't follow this.
Discharge petition is just pending.
It's a pending, my lord. Last occasion it was there, my lords, on 18 March, my lords. The case has been posted to, I think, this month, my lords. I don't know the exact date, my lords. The next date, my lords, for consideration of the discharge application. And all the materials for vigilance has to be
some date in this month for further consideration. Paragraph. In view of the above statement, the following directions are issued. 1. The petitioner is permitted to inspect the record in TR case number 8 of 2018 in the Court of the Special Judge Vigilance Cuttack and apply for and obtain certified copies of the documents that he requires. The documents be provided to the certified copies of documents be provided to the appellant not later than 1 week after he applies for them. 3. The Tahsildar who seized of the mutation case number the certified copies so issued by the Special Judge Vigilance and dispose of mutation case number 438 of 2017 in accordance with law within a period of 3 months thereafter.
Your Lordship may record my appearance, my lords.
Yes, yes. Yes,
I am Sangram Das, Standing Counsel, Vigilance.
All right. The writ appeal is disposed of.
Item number 99.
Your Lordship, I am sorry because I was there in the morning because of.
I know, I saw you here. Right.
Because of the extreme heat conditions, I had to come back home, Your Lordship.
Right.
I need a little time because the counter was filed on the last occasion. I need a little time to file a rejoinder, Your Lordship. Instructions I have sought for. I have not received the instructions, Your Lordship.
Mr. Mishra and Senior Counsel for the appellant states that he's still awaiting certain instructions on the counter affidavit filed by the opposite party, the respondent. List on.
May I request, my lord, for a short date? This poor man is suffering from cancer and has been, juniors have been promoted, my lord. I don't see any infirmity in the order.
21st opening days, 21st June. 21st June.
Your Lordship.
Opening day will have.
Grateful, Your Lordship.
All right.
Item number
Interim order
100.
to continue, Your Lordship.
Yeah, interim order to continue.
Grateful.
Item 100, similar matters, Lordship, are kept to 25th of this month, old pension rule matter.
All right.
Pass over.
Pass over.
Pass over matter, item number 17.
May I, my lord?
In this case, man.
May I, my lord? State it maybe in the first week of July, my lord.
Oh, all right. 3rd July?
Yes.
All right. 3rd July. All right.
Item number 17, minutes. In this case, I am appearing for the respondent, minutes. It's a case of regulation, minutes. Regulation of the data entry operator, minutes. Well, in fact, this respondent, minutes stands on a better footing than those of cases, Your Lordship.
Let me submit, Your Lordship.
Yes.
Your Lordship, page 131 of the improving order that has been I have challenged. That was passed, Your Lordship, without providing opportunity of hearing. And on this, no notice was issued to us, and it was simply directed us to regularize the service of the petitioner and so also consequence.
Let it go back, sir.
This is not a case of first day disposal, minutes. Interim notice was issued. Interim order was there, minutes. Thereafter, when the matter was listed up, minutes, the Honorable Court says that this case is exactly similar to Patris Bhavan Datta's case. Therefore, the case was allowed in that light, minutes. Your Lordship, I'll only produce one document. One document.
Order number 2, it says
No, interim order was issued, my lord.
On the no notice was issued to us, and it has been directed to regularize and with consequential benefits, Your Lordship.
No, there was no interim order. So very first day.
Second, and second fact that the judgment.
See, the first order was passed on 19th August. Sorry, it was the second order.
Yes, my lord. The interim order was there, my lord.
That's right. Only for 1 month. Correct.
There are, here I'll show your lordship only one document.
See, they are not appeared because within 1 month that there's no date mentioned. If you just notice, 19th August issue notice, it says.
Issue notice status quo were there, my lords.
No, that's right. Next date, they were not appearing.
They were not appeared, but
in fact, we have not received a notice, Your Lordship.
See, that's the whole point. The order should record that despite service of notice, he does not appear.
But here, my only one submission, my lords. I'll show only one document if a lordship is not.
They should give me a chance to respond.
Let me submit.
Okay.
Somewhere they have to file a counter somewhere.
Millard. And here in this case, no notice was issued to us.
It is seen that on 19th August 2021,
order is also covered by.
Notice had been issued by the learned single judge in Writ Petition Civil 24543 of 2021 without indicating any returnable date. But an interim order was passed directing status quo to be maintained. Paragraph. The present appellant was opposite party number 2 in the writ petition. We'll stop. The case of the appellant is that it was not served in the said writ petition and therefore could not appear before the learned single judge on the next date when the case was listed. That is 16th September 2021. Full stop. On that date, the writ petition was disposed of in view of the judgment dated 9th September 2021 passed in writ petition civil 19951 of 2020 bracket Patita Pavan Datta Dash versus State of Orissa bracket. The order sheet, the impugned order does not reflect the appearance of anyone on behalf of the present appellant, that is opposite party number 2 in the writ petition. Full stop. This substantiates the plea of the appellant that the said order was passed in its absence. Paragraph. Although this court has very recently upheld the above order of the learned single judge in Patipavan Datta Dash, Supra, given the fact that counsel for the appellant seeks to distinguish its applicability to the facts of the present case, and also since there was no opportunity to the appellant to file even a reply to the writ petition, the court passes the following directions. 1. The impugned order dated 16 September 2021 is set aside on the ground that the appellant did not have an opportunity to defend itself in the writ petition and restores the said writ petition civil 24543 of 2021 to the file of the learned single judge in the roster bench. 2. The said writ petition will be listed before the learned single judge in the roster bench on 7th August 2023. The present appellant will file its parawise reply to the writ petition on or before 24 July 2023. And the respondents, that is the writ petitioners, will file. That is, and the respondents, say, respondent number 1 will file his reply, his rejoinder thereto, not later than 7th August 2023. Next, no further time will be granted to either party for the above purposes. The learned single judge is requested to proceed with the hearing of the petition on merits and dispose it of as expeditiously as possible. The status quo order passed by the learned single judge will continue till then. The writ appeal is disposed of in the above terms.
Obligation.
Have you taken up tomorrow, my lord?
This is before which bench, sir?
This bench. A single bench.
CRLMC that is.
2019 matter.
Not interested.
Supplemental list fresh admission item number 1, CRLMC 3051 of 2019.
Nana based.
Item number 2.
May I please, ma'am? My previous name filed, but not to reflected my name. May I press, madam? The petitioner challenged the order passed by the SDGM Banki by rejecting my prayer not to further investigate the matter, madam. Challenge Annexure 4, the order, Annexure 4, page 39, madam, last portion. Hence, the power of under section 156(3) CRPC can be invoked by the magistrate before he takes cognizance of the offence under section 191A. But if he once taken such cognizance and embark upon the procedure embodied in chapter XB, he is not competent to switch back to the pre-cognizance stage and avail for section 156(3) CRPC. Hence, at this stage, this court has no authority to entertain such petition. Hence, he rejected, my lord.
Yes. What's your case?
My case is, my lord, praying for further investigation, my lord.
How is it possible? After taking cognizance, how can 156(3) be exercised? That's the question. After taking cognizance, how can 156(3) be exercised?
My lord, there is provided in section 156(1) CRPC, which does not indicate that the jurisdiction of the court in ordering further investigation after taking cognizance is barred by the provision.
What do you have to say, sir? Why is this order wrong? You are challenging this order, correct? Don't follow anything. All right. Counsel for the petitioner is unable to explain what error has been committed by the learned SDGM Banki in rejecting the prayer of the petitioner for ordering further investigation under section 156(3) CRPC. Paragraph. It is seen that the learned SDGM has correctly observed that after cognizance is taken, there is no occasion to order further investigation by resorting to section 156(3) CRPC. There is no merit to the present petition. It is dismissed as such.
Item number 3.
None appears dismissed.
Item number 4.
Item number 4, I'm in the VC mode, balance. Let's say, pray with your lordships in all the 6 matters. I'll raise all the grounds which I've taken herein before the trial court.
All right. Permitting the petitioners to raise all pleas at the appropriate stage. The petition is disposed of. Interim orders will update.
Item number 5.
No interim order.
All right.
Item 5.
None appears dismissed.
Item number 6.
I'm pleased, Lordship, my lord. In this application, the petitioner pays for quashing of criminal proceedings on the ground of compromise, my lord. Matter has already been settled with the
OP numbers 2 and 3 have filed their affidavits stating that the parties have settled their disputes and are living happily and peacefully. That view of the matter taking the prayer clause and all proceedings consequent thereto hereby quashed.
Item number 7.
None of this dismissed.
8.
raise all the point at the time of charge.
All right. Permitting the petition.
Item 9.
May I please, your lordships? Your lordships, it's an offense under section
13(1) and 13(2) of PC Act 1988. My lords, I have applied an application under section 207 for supply of a copy. Charge sheet has been submitted. My lords, the valuation report of a building in this case, they are not supplying me a copy, my lords. It's a case of DA. Without even a copy, how I'm going to defend my case, your lordships?
No, what has happened? There's no stay granted here. This is an order passed on 26 March 2018.
Your lordships.
Why don't you come to page 51, sir?
Your lordships.
Just read that first paragraph. Not silently, read it aloud.
My lords, it has been observed that this petition is not maintainable at this stage.
Why don't you read that entire paragraph, sir? I have asked the learned
Special PP Vigilance that in case the prosecution relies upon a document and intends to prove the same during the trial against the accused is entitled to a copy thereof before consideration of charge.
Why are you stopping?
But the learned special PP submitted that since the case is fixed for consideration of charge, after rejection of the discharge petition, the petition at this stage is not at all maintainable and should be rejected in limine as regards intention of the prosecution to prove the valuation reports of land and building owned by the accused during trial. The learned special PP submitted that the said reports are not material documents in the charge sheet and as such there is no possibility of proving the same during trial.
Then what is the
But your lordships, in page 46 they have mentioned that building and the report.
But they're not going to use it. That's what the PP has said. In the impugned order, the learned special judge, additional special judge Vigilance Bhubaneswar has in PR number 140 of 2006 observed as under, take top of page 51, the whole first paragraph in view of the above clarification of the special PP, the prayer of the appellant petitioner that they should be served copies of the valuation reports of the land and building is without merit. Accordingly, the present petition is dismissed.
Item number 10.
Infraction is dismissed.
Item 11.
None appears dismissed.
Item 12.
Infraction.
Item number 13.
Can I raise all the points?
All right. Permitting the petition.
Item number 14.
So item 14, the matter will become infructuous.
Okay. Dismisses infructuous.
Item number 15.
None appears dismissed.
Item 16.
Same order.
17.
Same order.
Item number 18.
Same order.
Item number 19.
Chalo. Well, here, challenging the order of cognizance. Here, cognizance taken under section 3 of the SCST Act, and also for offence under section 341, 323, 294, 336, 337, 34 IPC. After taking cognizance, I file an application for a discharge on the ground that this petitioner, there is a two FIR on the same date, and further another ground, the violation of Rule 7 of the SCST Act, since the entire investigation is being done by the Assistant Sub Inspector and only charge sheet is being submitted by the SDPO. So, my lord, thereafter, a magistrate, my lord, took learned special court, my lord, while considering my discharge application, he called for a report from the IAC regarding the veracity of 2 FIR. That so far my lord, I filed the document that has not, my lord, complied to the court, my lord. And so far, this is the that on that ground, I have challenged the order of cognizance because apparently case is, my lord, foisted falsely because 2 cases were there, 2 FIR are there. That report is called for by the, my lord, by the special court while dealing with the, my lord, my discharge application.
Will permit you to raise all, please, sir.
Pardon?
Will permit you to raise when you enter upon your defense.
I have already raised that point. That has not been, my lord.
What are you challenging here, sir?
Now, my lord, I'm challenging the order of cognizance, my lord.
If you say charge has already, discharge petition has already been dismissed.
No, that so far, my lord,
discharge petition is dismissed.
That petition was, my lord, report was called for by from the IAC. At further instruction, I don't know, my lord, whether the charge has been framed or not. Your lordship may direct me that I will raise the point, my lord.
That's what I was saying. So raise all grounds in the appropriate stage. All right.
Item number 20.
None of this.
Item 21.
Same order.
22.
22 may please your lordship. May I raise all the point law and court below.
Permitting the petitioner to raise all.
Item 23.
23 not placed, my lord.
Dismissed is not placed.
Item number 24.
May I please your lordship. Here, my lord, the petitioner number 1 is the mother-in-law, 2 is the brother-in-law, and 3 to 6 are the sisters-in-law, my lord. They have been entangled in the proceeding by the opposite party number 2, my lord. Although there is absolutely no allegation as against these petitioners, my lord. Entire allegation is against the husband. If lordship will see the complaint petition on the annex, I have filed, my lord.
There's no stay here. What is the stage of the proceedings? Charge has been framed or not?
Not framed.
So you take these
I will raise all the
permitting the petitioner to raise all pleas at the appropriate stage.
Item 25.
It's 25 minutes 40634 criminal prosecution, my lord. Petitioners only, my lord, my ground is that he, as a valuer only, he made the valuation in the bank and submitted to the bank who had sanctioned the loan. And he is in no way connected to any case as alleged, my lord.
Please raise all these please. Permitting the petitioner to raise all please.
My lord.
All right.
Item 26.
None of this dismissed.
27.
Same order.
Item 28.
Same order.
Item 27. Item 27, I am to the opposite parties. Copy not sought. Since
it's dismissed, sir.
Yes.
Right.
Item 29.
None of this.
Item number 30.
None of this dismissed.
31.
Yes. Here, my lord, I have challenged the proceeding initiated against the petitioner, my lord, who is a retired principal of Sonpur College, my lord. My lord, had that, my lord, may kindly see the affair, which is based on a audit report of a chartered accountant. I want to draw my lord's attention to the Annex 3, my lord, the local fund audit, the government audit. They have made the audit with regards to this particular period, and they said that everything is perfect and normal. But after registration of this case, again, that was verified by the authority, my lord, may see page 93. District audit officer, local fund audit, both. They said, whatever we have done perfectly and everything is perfect. But my lord, after the petitioner was transferred to another college as principal, the person who came in her place, he has done, my lord, mischief by doing it, the audit by a chartered accountant who is his person and has initiated the case to see that I will not get my retirement benefit. I have retired in the meantime. Why I have drawn my lord's attention to this is, my lord, since 2019, my lord, the case is pending. My lord and friend has taken instruction time and again to see what steps they have taken with regards to this audit report and which audit report they want to accept.
Yes, sir.
Your lordship may kindly see.
My lord, page 93, my lord, I want to say, my lord, inviting the kind reference to the letter of subject caption above, I am to say that as per the accounts review program of audit college made by the director of local fund audit, Odisha, Bhubaneswar, and alerted to different CE firms. The accounts review of the accounts Sonpur College to the handed over to 2015, 16, 16, 17, 17, 18 have been conducted by Vinod Kumar Agarwal and associates, so and so, respectively, but no such irregularities or any misappropriation was pointed out and reported by them in their respective audit reports. Further, as regards to the special audit made by Om Kejriwal and Co, Chartered Accountant, so and so Balangir, it is to be stated that the audit report published by Om Kejriwal and Co is not an approved audit report by the local fund audit office. So local fund audit has done the audit and found everything is normal. He has engaged one Om Kejriwal, chartered accountant, and say that I have committed misappropriation, and though I have retired, I'm not getting my pension and benefit and other things, my lord, because of pendency of this case.
My lord, this for the first time, the case was listed on 2/11/20, my lord. Thereafter, next date is today, my lord. It has been listed.
Let me obtain instruction.
My lord, what my lord senior submitted that we have taken several adjournments for taking instruction. That is not true, my lord.
All right, all right.
Yes,
But what's your instruction?
Yes, my lord. I'm page 23, your lordship may kindly see. My lord, I, Dr. Kedarnath Mishra, late Mishra, principal in charge of Sonpur College and ex-officio secretary of governing body Sonpur College, being duly authorized by the governing body by the resolution number so and so to file the FIR against Dr. Priyolata Jana, the present petitioner, my lord. Reader in chemistry, Sonpur College, Sri Abhinarayan Mishra, demonstrator in chemistry, and Sri Pramod Kumar Bagh, senior clerk accountant, for their collective involvement in the misappropriation of public money amounting to rupees 76 lakhs as detected by the special audit by Messrs. Kejriwal and Company. The attested copies of audit report, governing body resolution, and suspension order are enclosed.
My suspension was withdrawn. My suspension, my lord, by kindly see.
Has this formed the basis of any charge sheet? What is asking is what is the
nothing, my lord.
Well, the FIR has been lodged, but
sir, please, that was long ago. Are you aware or not aware? Then you say you're not aware.
No, I'm not aware, my lord, whether the charge sheet has been filed.
Counsel for the respondent, opposite party state, seeks time to ascertain what the present status of the investigations is and whether in fact the report of special audit by Messrs. Kejriwal and Company has been relied upon in the charge sheet.
Yes.
And also to obtain instruction on base 1993, madam.
It's all right. He has the
observation of the government, madam.
This for the roster bench on 19 July.
Yes, ma'am.
Item 32.
None appears dismissed.
33.
None appears dismissed.
Item number 34.
Same.
Item number 35.
Same.
36.
Same.
Item 37.
Permitted to withdraw with liberty.
Dismissed.
Item 38.
None appears dismissed.
39.
May I please allow? Here the passing of criminal proceeding on the ground of compromise, this application filed. The fact remains, lordship, the initially FIR against the 6 persons, and after completion of charge sheet, the present petition has been left from the charge sheet, and charge sheet submitted against 3 persons. They have faced the trial, and on the ground of compromise, the witnesses have not turned up. They have been acquitted. I have annexed the judgment copy under annex.
Pointed out to the trial court, sir.
No, on the ground of compromise, this is filed. I pray only 1 week, lordship, the OP will appear with affidavit.
What is the offence, sir?
The offence, lordship, 498-304B IPC.
304B.
Yes, sir. 302, 306, and 34 IPC.
This be compromise. What are you saying? What are you
Because I've annexed all the documents, lordship, the evidence laid.
B, how can they be compromised?
No, the evidence laid against the main accused persons, the father-in-law, husband, and mother-in-law, they have been acquitted.
Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
Item number 40.
40, ma'am, please, your lordship. On the basis of the compromise petition under section 13B of the
Korsag, it has been annexed as to Annexure 2, page 18, my lord. By way of amicable settlement, 13B award was passed. And the marriage
Alright,
was
counsel for the petitioner relies on copy of the decree granting divorce by mutual consent under section 13 capital B of the Hindu Marriage Act 1955. Notice returnable in the roster bench. 24 July.
interim order to fund.
There's no interim orders. It's all right.
My lord, interim order was
Nothing
there.
happens. Here it's automatic. The minute I think 482 is filed, everything comes to a halt. Yes.
Item 41.
None appears dismissed.
42.
Save.
Item 43.
None appears.
44.
I have to raise the point, my lord.
Permitting the petitioner to resolve, please. All right.
Item 45.
May I please, Your Lordship? My lord, here in this case, the offence is under section 138 of the NI Act, my lord. And I have challenged the order of taking cognizance on the ground that, my lord, there is no legal liability to discharge, my lord. And in this connection, I will only cite one decision of the Honorable Apex Court, my lord.
Been cited before the trial courts.
My lord, because the cognizance is already taken. A complaint petition that was appreciated by the trial court and cognizance was taken, my lord. But here in this case, in the Apex Court judgment, my lord, it is clearly stated that if there is no legal liability, my lord, then this is to be quashed, my lord.
It's all right. Permitting the petitioner to resolve, please, at the appropriate stage. The petition is disposed. Right.
Item number 46.
None appears dismissed.
47.
Prayer is for quashing of criminal proceeding on the ground of compromise. For 98 offense is there, for 98 other offenses, your lordship. In the meantime, mutual separation has been made, your lordship. I will file all the.
All right. Counsel for the petitioner seeks time to produce documents to show that divorce decree has already been granted and parties have settled the disputes. List before the roster bench on 3rd July.
Item number 48.
None appears dismissed.
49.
All right.
Item 50.
None appears dismissed.
Item number 51.
Same order.
52.
Same order.
Item 53.
Maybe, your lordship, the limited pay of the petitioner that lordship, your lordship petitioner is an informant. He filed a petition under the complaint petition that the opposite party number 3, which is Miss Sandhani Raut, alias second, both are same person. He filed a petition and London trial court. Grass lordship, page 15, is stated that last name, in my considered opinion, as there is no provision in CRPC to amend the name of the accused person in the complaint petition in the stand rejected. Your lordship, several decision is there, lordship. The complaint petition can be amended. I also some citation is there, lordship. The Bombay High Court stated that where is wrongly mentioned in the complaint and complainant may be permitted to amend his complaint as per the Honorable Court Magistrate has a.
Where are you reading? What are you reading?
There is a decision there, lordship.
Which decision, sir? You're not even giving the name of the decision.
Only prayer that the Somer.
Which decision? Which decision are you citing?
Lordship, here, lordship, 2012 October Bombay High Court, lordship. And lordship, on the year 2015 756, they also stated that, lordship.
The 2015 756. No court.
The court is Honorable Justice S.R. Kumar versus.
You don't have a copy of the.
No, I will next. I will solve.
Only that needs time to cite decision. This for the roster bench on 11 July.
Otherwise, lordship, that amendment petition may be considered.
Item 54.
None appears dismissed.
55.
Memo taken on dismissed as not pressed.
Item 56,
None appears dismissed.
item 57,
Same order.
58,
18 infractors, my lord.
Dismissed as infractors.
item number 59,
None appears dismissed.
60,
Same order.
item 61,
Same order.
62,
Same order.
item number 63,
Same order.
64,
Same order.
item 65,
Same order.
66,
6, may I please, your lordships? My lords, I have challenged the order of cognizance. The case is that, my lords, there is allegation against one president of one SSG group and one transporting agent for misappropriation of 960 bags of wheat, which are kept for the special nutrition program and emergency feeding program of poor children, my lord. So they have misappropriated that wheat, for which 2 cases has been instituted. The present petitioners has been taken in remand in a previous case, which has been instituted by the transporting agent to save his own skin. And now in this case, the prosecution is alleging that these present petitioners are the custodian of those wheat, for which absolutely there is no material. And they have been implicated in this case, and no charge sheet has also been submitted, my lord, against the main offender.
Because you have filed this petition, that's why. You say none, permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed. All right.
item 67,
My lord, 67, 2 application is there. Both the matter, my lord, in the meantime compromise, we have filed the joint affidavit, your lords. Kindly
All
see.
right. Counsel for the informant confirms the affidavit filed, joint affidavit filed, stating that the parties have entered into a compromise and settled all the disputes. It stated that the informant has married another person and is residing happily with them. And petition number 1 has also married another person and is residing happily. In that view of the matter, it's the prayer clause and all proceedings constant that to hear the caution.
Second item, my lord, filed by the boy, my lord, against me. The second item is there, my lord.
All right. Same. Both matters and both prayers you take. All right.
item number 68,
68, and appearing in the first sub-item. The petitioner in the first sub-item is dead, my lord. Filed a memo enclosing the death certificate, my lord.
So that's abated. In the first matter, a death certificate showing that the petitioner is expired.
On 24th of February 2022.
24th February 2022 has been placed in record. The petition is disposed of as having abated.
Obliged.
My lord, in 67, only in the first case, only petition number 1. Other are not charge sheeted.
Prayer is confined to prayer petition number 1 only, because others are not charge sheeted. This is the charge sheeted.
All right. Petition number 1. All right.
68.
What about the second sub-item?
Second sub-item is from other council.
Other council. My lord, I am the last sub-item, that is, my lord, kind permission CRMC 1721/2019, my lord.
So next to 1312 and 1313, you say none appears dismissed. What is 1721?
My lord, 1721, my lord, in the meantime, the department has accepted the compounding fees and nothing subsists in this case.
And the petitioner states that due to subsequent developments, the cause of action does not survive. The petition is disposed of.
Already in all the matters, I am appearing for the department.
Or
in all the.
These 276B income tax matters.
All right. Okay.
Yes, my lord.
All right. All right.
item number 69.
Last item, my lord, sir, my appearance may be kindly recorded.
Yes.
Well, grateful.
69.
None appears dismissed.
Item number 70. 71.
May I please, your lordship? The affidavit filed by the informant, annexure 3, page 14, my lord. Arising out of complaint case, already all paragraph 3. That in the meantime, matter has been settled between us, and I have already received the total amount, my lord.
All right. Counsel, the petitioner states that due to subsequent developments, the present petition has been rendered infructuous. This is post office section.
Already, my lord, it is pending. I have filed for quashing of cognizance on the ground of my lord affidavit filed annexure 3 by the informant.
No, but where is that affidavit of compromise?
It is filed before the court below.
So that's why. So due to subsequent developments, it's already been. The present petition does not survive. It will be open to the petitioner to raise all pleas before the trial court at the appropriate stage.
Item 72 direction in this case on 26/11/2019 to state to take instruction.
What instructions are you can imagine they'll have no instructions. Better the trial court does it. All right.
72.
72, may I please? Here, my lord, the married daughter has filed a case, domestic violence case against father and brother. She has already married and residing in her in-laws' house, and she filed case of domestic violence case against the.
Basically, she will not appear in the trial court then. Either we get her affidavit, otherwise point out to the trial.
My lord, it cannot be quashed because continuance of the proceeding is abusive process. My lord, it is not maintainable under the Domestic Violence Act.
Point out to the trial court, sir.
So the lordship
permitting the petitioner to raise all pleas at the appropriate stage.
Lordship, I am appearing to the opposite party number 2.
But what happened, my lord? Can you drop the my lord because the 482 the lordship has inherent power to quash the proceeding. And otherwise, the lower court has no power to quash the proceeding.
Who's asking you to quash the proceedings in the lower court, sir? There are other provisions of CRPC. Don't expect me to conduct a class for you. All right.
So that's
I'm not saying that the lower court quashes proceedings. All right.
So, my lord, the abusive process because the person is father.
Sir, I am not here to take class for you under CRPC. You are a very learned counsel, long years of experience. All right. So you know which.
So my respectful submission, my lord, when it is not maintainable the case, under the act. So why the person's petitioners will be harassed and will be and the waste of the public time and that is
I'm not here to give free legal advice. All right. Next part.
Item 73.
Yes.
73.
Yes. None appears dismissed.
Item number 74. May I please, Your Lords?
Yes.
My lord, the petitioner before the Lordship has challenged the order of taking cognizance, my lord.
Yes.
My lord, there is not a single iota of evidence attracting the offence under 420, my lord. Kindly peruse, my lord, annexure 3, page 15.
All right. You can take all these pleas. Permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 75.
75, I am pleased, Lordship, my lord. In this application, the petitioner challenges the order of taking cognizance under 10 of Equal Remuneration Act, my lord. Petitioner already resigned from his directorship, my lord. I have annexed the, my lord, page 23, my lord. The petitioner already resigned from director and Form 32 has been filed since 1996, my lord. Case has been instituted in 2003, my lord.
I see. Where is that?
Madam, page 23, my lord.
What do you say, sir? You ceased to be a director long ago.
If yes,
It's only harassment then.
before the trial court at the time of charge, my lord, let him consider by the trial court.
Why should if there's a statutory document of notice of ceasing to be a director, that's more than enough. Form 32, right?
No.
Annexure 3 is the Form 32, which shows that the petitioner ceased to be a director of the accused company since 1996, whereas the complaint in question was filed only in 2003. This document has already been placed in record and it's not disputed by counsel for the opposite parties. Consequently, vis-a-vis the present petitioner, the order passed by the learned SDJM on 7/11/2019. Taking cognizance.
17/5/2003. 17/5/2003. Page 10, man.
Order dated 17/5/2003. Taking cognizance under Section 10 of the Equal Remuneration Act in 2CCC number, case number 28 of 2003 shall stand set aside. The petition is disposed of.
76.
In respect of the petitioner, your lordship,
That's what I've
other
said.
accused are there.
I've said that.
And the entry order may vacate because
Item 76.
My lord, may kindly have a glance to Annexure 4 at page 39. Here, the compromise petition was filed before the court below. The parties have compromised the dispute. The non-bailable offense is only 506. I prayed for question of the entire proceeding. He has also appeared.
Yes, madam. I am for the OP number 2. Counsel for OP number 2 confirms that the parties have indeed entered into a compromise, copy of which is at Annexure 4. In that view of the matter, take from the prayer clause and all proceedings consequent that were hereby quashed.
Well, the entire proceedings. Gratefully, Your Lordship.
Item number 77.
May I please, Your Lordship? Here the petitioner challenges the very initiation of the filing of the maintenance case by the wife, opposite part number 2, before the learned judge, family court, Cuttack. Because the wife is staying at Bangalore on behest of the brother-in-law, this petition has been filed. I have taken the stance. And the petitioner has also made a representation before the learned judge, family court, Cuttack, Annexure 4, Your Lordship may kindly see, to cause an inquiry into the matter and to pass necessary orders. But the representation is still pending.
Where's the question of representation and all? It's a criminal case. Where's the question of representation?
Because I have taken the stand that that petition under Section 125 CRPC has been falsely filed by fabricating and working the signature of the wife.
Demonstrated in the trial court, sir.
So Your Lordship may direct the learned judge, family court, Cuttack to dispose of my representation or Annexure 4.
There's no representation. That whole concept doesn't arise.
And in spite of the notice issued, nobody has yet appeared.
It's all right. Permitting the petitioner to raise all pleas in the appropriate stage, the petition is disposed of. The interim order is completed. Right.
78.
78, no instruction.
No instructions.
Item 79.
Please, my lord.
Yes.
Lordship may look at Annexure 4 at page 15.
Yes.
That is a judgment in a previous affair filed by the same informant, where my mother and myself were accused. On 4/11/2012, she had lost the FIR, alleging that on 27/12/2010, I had taken a personal loan from her, did not repay it once, and when she asked for that, I abused her and threatened her. I got acquitted in this case, my lords.
Yes.
After being acquitted, another FIR was lodged, my lords. That is at page 9. They are the same allegations, my lords, but the date is changed. The date of taking of loan is 28/12/2011. And on that, my lords, investigation was taken up. My lords may look at Annexure 3 at page 14, my lords.
No, what happened? Notice was issued. AD served.
Postal requisites have been filed, my lords.
Valid service.
Now, my lords may look at the order of cognizance at page 14. Cognizance is taken where I have been shown as an absconder. No warrants were issued, nor summons were issued. Thereafter, my lords, on the prayer of the police at page 12, by a subsequent order, NBWs have been issued against me.
What do you say, sir?
Yes, my lord. My lord, your lordship may kindly see 19/8/2015, the case record is put up today. The IO has made a prayer for issuance of NBW against the accused person, namely De Srinivas Rao. It is found that there exists prima facie material against the accused for commission of offence under section 420, 406, 294, 34,
Hence, prayer of the IO is allowed issue NBW.
How straight away NBW?
Like
Only if the person absconds, you issue NBW. Where's the person straight away issuing NBW?
Before he filed a charge sheet, my lords, he makes a prayer for NBW, shows me as an absconder.
What is all this? Anyway, this order has to go. This order is clearly illegal, sir. It is seen that on the very first day, even before the...
Lordship, may kindly see 21/12/2015 order, my lord.
21?
21/12/2015. Here in this order, my lord, the IO has submitted charge sheet.
That is second date, sir.
Yes, my lord.
But even before submitting, NBW is issued.
Yes. Yes.
How is this?
Yes, my lord.
It is seen that on the very first day, when the case record of GR number 486 of 2015 was put up before the SDJM Berhampur, even before a charge sheet could be filed, NBW was issued against the present petitioners. Counsel for the state is unable, present petitioner, counsel for the state is unable to justify such an order. Stop. The subsequent date when charge sheet was filed, cognizance was taken. Subsequent date, that is 21/12/2015, when charge sheet was filed. Cognizance was taken of offences under sections 406 bracket /20 420/294/34 IPC. And summons were issued to the accused, including the present petitioner. Paragraph is pointed out that the above order was passed without noticing that on 28/4/2014, by judgment dated, a judgment was passed by the Special Judicial Magistrate Berhampur in GR case number 1524 of 2012, acquitting the accused, including the present petitioner, of identical allegations
by the same
informant, with only the date being changed. No, then loan amount being changed.
Loan amount has been changed, date has been changed.
Date and loan amount being changed. So this appears to be a clear case of non-application of mind by the trial court. Paragraph. For the aforementioned reasons, the court sets aside both the impugned orders dated 19/8/2015 and 21/12/2015 passed by the learned SDJM Berhampur. And the said case will now be listed before the said court to be resumed de novo.
If your lordship will fix a date, I will appear and the court may consider my prayer for.
On 19 July, on which date the present petitioner will appear before the court. Till then, the NBW issued against him will not be enforced. Full stop. Thereafter, it will be open to the petitioner to apply to the said court for appropriate directions.
Which shall be considered appropriate.
Yeah, which shall be considered in accordance with law. Right.
Urgent copy.
Yeah. Petition is disposed. Urgent.
Item number 80.
Item number 80, I am appearing on BC, your lordship. I may be permitted. On the ground of compromise in the court below, they have been acquitted, your lordship.
All right. Counsel for the petitioner states that due to subsequent developments, the present petition has been rendered infractions. It's disposed of as such.
Pass to matter item 49. May I please, your lordship? My lord, a contractor, he says that I'm filing a translated copy, your lordship, for my lords, that the informant had entered in the agreement to construct my house, my lord. This happened sometimes in 2010. And according to the FIR, your lordship, he delivered possession of the house in 2012. The total, out of the total consideration of 1 crore 7 lakhs, he alleges that I have paid him only 60 lakhs, balance 47,000 is to be paid. And for this, he has lost this FIR saying, my lord, that kindly, a समस्त घटना तदंत करी मोर प्राप्य अवशिष्ट अर्थ I should get back the rest of my amount. That is his allegation. And on the basis of this, FIR has been registered.
But no order passed here, sir.
My lord, the corona intervened soon after filing it, and there was no hurry in the trial court either. And your lordship,
You can point this out to the trial.
my lord,
You can raise all pleas at the appropriate time.
my lord, I am coming back, your lordship, next week after removing the defect. Your lordship, I consider it on a merit. There is nothing, your lordship. I am filing a proper translated copy also.
All right. At the request of Mr. Sarangi, who wants to file translated copies of certain documents. List before the roster bench on 17th May. All right.
33 dismissed for default. I could not come. So let it come next week. Your lordship, so
No,
please.
what is 33?
That is a scientist, my lord, instead of the agriculture scientist fighting litigation with his wife, one or the other. Now the allegation is that while she was with me, I not only abused her, but also
that you say permitting the petitioner to raise all pleas. 33 is permitting. All right. All right.